Acha, before you start, I had been, there was a request made from the bar that since there's going to be a meeting at 1, can spill over beyond 2, if the court should start at 2:30. Well, the court will start at 2, but we will accommodate those who cannot make it during that period. 2 to 2:30, they cannot, we will accommodate, we maybe adjourn the matter or accommodate for some more time. Yeah, but we will start it.
May I please, Your Lordship? I'm praying for listing of a matrimonial appeal, Lordship, on 5th, Lordship. Lordship, urgency is there, Lordship, it is pending, that is why they're hanging both the husband and wife, that's why.
You have filed the appeal.
Yes, I have.
Your application for mutual divorce was rejected.
No, that was not major. I mean, the divorce suit was there, mutual divorce was not there. That was rejected by the family court, Lordship. And against that order, I have to.
Okay, anyway, right. Right, okay.
On 5th, Lordship, deeply.
Lordship, item number 15, 16, 17. I am appearing in 16. Two of my colleagues are appearing in 15 and 17.
Yes.
Lordship, in this matter, direction was issued for filing an affidavit on this for PTC authority law. That instruction is awaited. My problem is that already election has been declared there, and herein we have to take a decision at the political level. So I have already informed my colleague Lordship in the other side.
Okay, right.
So I'm
Mr. P. Nayak appearing for the BTC. Please for how much time?
I'm paying for 4 weeks.
Please for 4 weeks time to file affidavit.
Millards, I
However,
seek,
besides submitting that the elections to the BTC has been announced. Mr. M. Sarane, learned counsel for the petitioner, submits that he has got no objection to the same. Accordingly, release this matter after 4 weeks.
Of that, 16, 17.
I seek my lord's indulgence,
Yes,
Millards, to mention item 10,
yes,
10 to 14.
yes.
I had some difficulty, personal difficulty today, Millards, to travel to Guwahati.
Yes.
So I was requesting if it could be on a date next month
Yes.
of my lord's convenience, preferably, my lords, subject to my lord's convenience on September 24th, my lords.
Who's for the other side?
The state,
Any objection?
No, Lordship, 24 is fine.
Okay, right. On the prayer for adjournment made by Mr. Krishnan Venugopal, senior counsel, for the appellants, which is not objected to by Mr.
A. Chandran, Lordship.
A. Chandran,
Senior,
CGC,
the senior government advocate,
government advocate,
Arunachal Pradesh.
Arunachal Pradesh. For the petition. List the matter on 24/9.
I'm most grateful to your lordships.
Yes,
May I please, Your Lordship? My lord, I beg to mention item number 1 and 25, my lord.
1 and
And
20.
25, my lord. One is, my lord, in both in the motion category, my lord. We are being led by a senior counsel outstation, my lord.
Ah,
So there are certain difficulty today, my lord. Can it be taken up online?
the full form of BTC,
Lord, Bodoland Territorial Council, my lord.
Bodoland Territorial
This is
Bodoland.
this is a, my lord, student organization, my lord, under that.
How are they involved with this Bengali speaking persons?
Because, my lord, in
Bengali, this Bodoland Territorial Council.
there are Bengali speaking people are also there, my lord, residing there in laborers are migrating to the other part of the state. And my lordship is well aware, my lord, that they are being threatened, beaten,
I don't know about
my
that.
lord, and pressed from certain parts of the state. So, my lord, only my senior has been make a request before my lordship to fix another date and coming week, my lord. Item number 1 and 25, my lord.
Who is appearing for the other side? DA and DA.
CGSC is also.
So we adjourn the matter. All right, adjournment prayer has been made by Mr. A.R. Bhuyan,
My
learned counsel for the petitioner, who submits that he is led by Mr. Santosh Hegde,
Mal Sanjay Hegde.
Sanjay Hegde,
Mal.
another senior counsel,
Mal.
who is having some personal difficulty to. He accordingly prays for adjournment. The same not being objected by Mr. R.K.D. Chaudhary, Deputy SGI. This is the matter on
Next week, can you take me? Monday or?
No, this will go before the court number. When do you want?
My lord, on coming Monday, my lord.
Monday. Wednesday.
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 My lord, I have another prayer.
1 and 25, huh?
One and two. Yes, sir. My lord, I have another prayer, my lord, as regards item number 18, my lord.
Yes.
My lord, due to my personal difficulty, my lord, I could not prepare the brief yesterday, my lord. Some medical, my
2000 matter, Mr. Council.
My lord, only one day accommodation I am seeking because of medical emergency, my lord. I was attending my niece nephew, my lord, in the hospital yesterday night, my lord.
Who's appearing for the other side?
The J. Assam is there, government advocate.
Mr. A.R. Buyan, the counsel for the petition, appellants,
Appellants.
prays for adjournment on the ground that due to some medical emergency,
Fine.
he could not prepare the case.
My,
So accordingly, leave this matter. Next week. Move it. Next week or Friday, when do you want?
next week,
Why next week?
Lord,
Well, yes.
next day prepare.
Oh, Monday.
My. Obliged, my lord, deeply obliged.
May it please, my lords. Prayer for listing of a motion matter, my lord. It's a PIL, my. If it pleases, my lords, it may kindly be listed tomorrow, my.
Not tomorrow. Why? What's the hurry?
My lord, this is regarding relocation of a Anganwadi center, my lord. The proposed site where the new Anganwadi center is going to be constructed, my lord. There are certain, I am deeply obliged, my lord. I'm sorry. My lord, one more mention, my lord. It's a criminal appeal, my lord. As for your lordship's convenience, my lord, any day.
New matter.
No, my lord, pending matter, 2022 matter, any date as per lordship's. Next week. Wednesday. Deeply obliged, my lords.
May I please, your lordship? I'd like to mention item number 38 of the supplementary list, your lordship.
Yes.
In this matter, lordship, senior advocate Mr. R. Sharma is out of station, so I'm praying for some accommodations, lordship.
Last, have you read the last order? This is what we told you last, a few days back. That even if you are absent, we will dispose of the matter. You knew
Lordship
it.
on Monday, lordship on Monday, lordship. Lordship,
You argue the matter. You can go to Supreme Court otherwise.
well, lordship tomorrow. then.
Huh? No.
He's out of
We have
station.
already told you beforehand. You can go to Supreme Court.
No, lordship. So just for today, lordship.
Huh?
Just for today, lordship.
On the, where is Mr. R. Sharma?
He's out of station, lordship.
Why? Knowing fully well that it was listed today.
He'll be present tomorrow, lordship.
Running away.
No, lordship, he has some work. No, lordship.
Correct. On the prayer for adjournment made on behalf of Mr.
R. Sharma.
R. Sharma is not there.
So he's appearing on this.
Where is his wakalat?
Lordship senior.
R. Sharma. He's a senior. Okay, Mr. R. Sharma, okay. On the prayer for adjournment on behalf of Mr. R. Sharma, that is senior counsel for the applicant. List the matter. On Monday.
Obliging.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 36. My senior Mr. H.K. Das is having some personal difficulty today, lordship. Any other date?
Okay, right. On the prayer for adjournment made on behalf of Mr. H.K. Das, counsel for the
Petitioner,
petitioner.
lordship.
List the matter.
Any date, September, lordship.
Give it.
Ninth.
What is the matter about?
We're challenging rule, lordship.
Give also nine.
Rule 5.5 of Secretariat Service Rules, lordship.
Give 115.
Lordship, much obliged, lordship.
Yep, yes, sir. Back to mention item number 6, my lord. My lord, what have we taken on next week, my lord? We have some difficulty to. Item number 6.
Why?
Senior have some difficulty, my lord. Next Friday, my lord.
Basically, a past service prior to provincial. You want them.
5th of September, madam.
Just give me that, right. Where is he? He's in court.
Yes, madam.
Where? Why? What is the reason for adjournment?
That is not prepare, madam, because last night, yeah.
You filed it. What do you mean? You filed it with the eyes closed? Did you make the appeal petition with the eyes closed? So you know very well what the issue is.
Next week, madam.
Why? You tell him to come.
I apologize, Lordship. Could it be 19th September?
Okay, 19th. Item?
36. Much obliged, Lordship.
May I please your lordships? Lordships, by the order dated 22/5/2024 in contempt number 775 of 23.
No, let us see the order.
Yes, lordship.
Okay.
Order starts at page 24. In fact, the state has admitted through the submissions of the learned AG also. May I read it? This contempt petition is filed by the petitioner complaining that the order dated 17/11/22 passed by this court in writ appeal number 304 of 2021 has not been complied with by the respondents. The operative portion of the order dated 17/11/2022 reads as under. Today, during the course of hearing, Mr. S.P. Chowdhury, learned counsel for the appellants, had placed on record a site verification report.
Has not been paid.
Lordship, initially the matter was relating to handing over the possession of the land. Now, when that was not done, Lordship, we filed the previous contempt where, my lord, the learned AG along with the deputy commissioner made a submission before this court that the government is willing,
So this amount has not been paid.
not paid, Lordship.
Heard, Mr.
Yes, sir.
A. Sharma, learned counsel. Appellant.
For the petitioner. Lordship.
For the petitioner who submits that the order dated 22/5/24 passed in contempt case C 775 of 2023 arising out of the order dated 17/11/22 passed in WA 304 of 2021, by which the petitioner was to be paid ₹1 lakh.
No, Lordship. Actually, later on, 1 lakh was to be paid as per the,
How much is to be paid?
that is rupees 78 lakhs per katha, which is to be assessed, has been assessed.
By which the compensation was to be paid
Yes, Lordship.
has not been complied with. Till date. Issue notice returnable in 4 weeks. Applicant to take step for service of notice upon the respondent by registered post proceeding within 2 days. This is the matter of the following.
Obliged, Lordship.
My lord, the contempt petition, page 11 is the operative, my lord.
Mr.
Page 11.
A.S. Tamaria, learned counsel for the petitioner, submit that the order dated 18/6/2025 passed in 1949 of 2025, by which
Page 30.
the district magistrate Kamrup was to take requisite step for taking over possession of the secured assets of the bank in accordance with section 14 of the SARFAESI Act, has not been complied with. Issue notice returnable in 4 weeks. Steps within 2 days. Get the matter.
Deputy.
Please, your lordship, we have summoned the order 12/10/2020, that is page number 118, my lord. Page number 118, operative person is page number 122. One 22 para 9, respondent are directed to grant disability element to the applicant with effect from
What
date
is
of-
wrong?
My lord, that is as per rule 173 of the Pension Regulation Act, they are not entitled for that. That is in page number, my lord. Rule is in page number 107, my lord. My lord, bands of cases are pending before the court, my lord, and this is the similar, my lord, order of the. Rule is in page number 107, my lord. This is the type copy, my lord. One 173, my lord.
So the disability is what? Is
Visible,
it attributable to
Yes.
the military service?
attributable to the agreed by the military service. Yes, my
Ah.
lord.
So if it is then,
Madam, they don't have the, their disability is not attributed to military service, madam. Kindly see page 173, madam.
178? No, military service doesn't mean that they have to go to war.
Yes, my lord.
If it's in service, then it's all right. As long as they are in service, then they won't they come under this 173.
My lord, then another provision is also there, madam.
Look, the
My lord.
person was returning from duty, correct?
Yes, my
From
lord.
leave,
Yes, my lord.
correct?
Yes, my
He
lord.
was returning to duty from leave. So he was still under service.
Yes, that is, it is,
Do you mean to say that military service would mean that it has to be something to do while he was not on leave?
yes, my lord.
Huh?
My lord, there is another provision also there, my lord.
Very narrow. We can decide the matter now also if you want.
Yes, ma'am. Now, my lord, then after some time at 2 o'clock, ma'am. But the similar cases are pending, lots of cases are, if honorable court want to decide, then I'll, my lord, at 2 o'clock then, my lord. I'll take care on according to that, my lord. This. Otherwise, may tag along with this matter, my lord, WPC 9.
How is 173 not attractive?
That is not a, my lord.
He went on leave. He was coming back from leave. Then then that is where he had an accident, correct?
Yes, ma'am.
Injury.
Yes, ma'am.
So how is it not covered under 173?
After some time, ma'am, I have taken my notes somewhere, my lord, after some time, my lord. My note is there, ma'am. My lord. After some time, my lord, I have prepared that whole case, my lord. I have taken my notes somewhere, my lord. After some time, my lord.
You should have brought it now. This is the time you need your notes.
Yes, my lord, after some time.
Let's see. What could be.
Yes, ma'am. If-
You see, Rule 9.
my lord.
Rule 9 defines duty, correct?
Yes, my lord.
Now, Rule 9 defines duty and sub-rule D states that a person returning to duty from leave station is covered by the definition of duty.
Yes, ma'am.
Then if he is returning from leave and he sustained injury, then isn't he covered under 173?
173 says that unless a specially provided detailed pension may be granted to the individual who is invalided out from the service on account of disability which is attributed or to aggrieved by the military service is that. But they are, my lord, here the kindly see the line. Unless other specific provided disability pension may be granted to the who is invalided out from the service. Here they are not invalided out, my lord, in this case, my lord.
But he has to be invalidated out. Now he has to be invalidated out if his injury. Can he continue in service?
But they are,
Is he allowed to continue in service?
no, no, my lord, but they are
Not
the,
allowed to continue in service, he has to go out. If you're allowing him to continue in service, then we will say that let him work, continue working. But if you're not allowing him to continue in service, basically implies that you're invalidating him out of service.
and another rule is also there, my lord, that is another rule is also there, my lord, for which they are not entitled for invalid, my lord, disabled pension.
Okay. We'll issue notice.
My lord, matter will be stable.
No.
No, my lord, similar matter has already been stable, all the
They have not been able to convince us.
My lord, kindly take at 2 o'clock, my lord, I will convince at 2 o'clock, my lord.
Let the interim will be decided on a future date. We'll issue notice on the interim.
My lord, kindly at 2, my lord, I will decide.
No.
Because
MFSC.
execution proceeding is pending before the AFT, my lord, that's one.
So we are issuing notice on the interim.
Yes.
So then you tell you tell the tribunal that there is a notice issued on the interim.
Yes, my lord.
Right. Heard Miss Agan, Leonard CGC. Who submits that the impugned order dated 12/9/23 passed by the Learned Armed Forces Tribunal, Regional Bench, Guwahati in OA 28 of 2021, allowing the appellate allowing the appellant directing that the appellant is entitled to disability pension should be set aside. First up, she submits that in terms of Rule 173 of the
170 of Armed Force Regulation,
what is that?
that is in page number 107.
What is this called that?
Pension regulation for Arm Act, Arm 1961, my lord.
Is it rule or what?
This
Rule?
is rule, my lord.
Rule 173 of the
Arm, pension regulation for the Arm 1961, my lord.
where is that arm? What do you mean arm?
My lord, rule, yes, my lord.
Where is that?
That is, my lord. Rule is in
Yes. Which rule?
1973, my lord.
What is the name of the
Yes,
rule,
my
madam?
man giving that rule, my lord.
No preparation at all. First time
Oh.
is being listed in for no preparation.
No, my lord, I have that, I have Take it. My lord, pension regulation applicable to Army 1961, my lord.
Pension, so it is not rule, it is a regulation.
Yes, my lord.
Regulation 173 of the
Of the, my lord, pension regulation
regulation for the army 1961
61, my lord.
bracket part 1.
Yes, my lord.
Issue notice returnable in 4 weeks. Also issue notice on the prayer for an interim order. Appellant to take step for service of notice upon the respondent by registered post with AD within 2 days. This is the matter on, give a date.
That's it.
This is also.
Lordship, my call yesterday, exactly similar matters were
Technical resignations.
heard and dismissed by this honorable.
Okay, I heard Mr. S. S. Roy, London CGC appearing for the writ petitioner. Writ petitioner.
Lordship.
Also heard Miss
D. Mohantal,
D. Mohanta, Learned Council appearing for the
respondent one,
respondent number 1.
single respondent.
For the respondent number 1, huh? Then this is, you take yesterday's order in WPC 4800 of 2025. Lordship. Okay, it's 4800.
There are minor differences, Lordship.
Only the final. Out here, he was working as
He was working as junior engineer, SSC drawing and design, Lordship.
JE
Drawing and design.
JE/SSC,
SSC
SSE,
E
E,
SSE
drawing and design,
drawing and design.
design.
And he had applied for
Civilian.
See on 7/5/2019.
no, that is all right. The advertisement is the same.
Yes.
He has
This is
engineer
Senior engineer civil.
and Lordship, the OA number is different. Lordship.
OA number will be
195.
of 2025.
195 of 2025.
And order date is
27.
27/6/2025.
27/6/25. Okay.
Shubhlash.
So did I? 6. David is that as the respondent number 1 has entered the appearance, David can to start. Yes,
So to say, Malat, as underprepared, Malat, that is why Malat,
you are not prepared. Why? What is the issue here?
The issue here is that Malat, the rule by which the selection to the post of principal is made. The petitioners, they are Malat, newly provincialized postgraduate teachers.
You were provincialized when?
1/1/13.
1/1/13.
But Malat, they are serving since Malat, decades.
No, maybe decade.
Yes.
But prior to 1/1/13, you were working in a private school.
It was provincialized, not
Provincialized when?
but the financial assistance were given to the schools.
Maybe. When was your service provincialized?
On the 13.
1/1/13. So you came into the cadre. You're born into the cadre only on 1/1/2013. Now, what is the years of service required?
15 years of service is
So
required.
you have not completed 15 years.
Yes, Malat,
Then-
that is why Malat, the rule is under challenge.
No,
Malat.
what is that is applicable to everyone.
Malat, this rule, the provincialization order itself, it says that Malat, the initial appointment, date of initial appointment is mentioned. Possible see that the date of initial appointment is mentioned.
Date of initial appointment as a government servant, not as a
Lawsuit kindly split.
teacher.
Provincialization order lawsuit final case 45.
45.
Mile.
Yes. Yes,
Rona Bora serial number 4, Mile.
yes.
Is in this date of joining is shown as 21/8/1996
Date of joining where? Date of joining where? In the private school.
in the school, Mile.
In the private school.
On the basis of this date of joining only, Malat, his service was provincialized. And my lord, he's doing the same nature of duty.
You see, there are persons who have joined in 2001 also.
Yes.
In the same order.
Yes, yes, my lord, yes.
Okay. So that does not give you any right. Now, which is the rule under challenge? Let us see.
Rule 12. 3, Roman 2, my lord,
Page.
page 32.
Page 32, Roman 12, 12,
12, 3, Roman 2, my lord.
12, 3, Roman 2. Yes.
The candidate must have rendered at.
So you're challenging this 15 years of service.
Yes,
Why? On what ground?
because my lord, in the high schools, my lord, those persons who were working as headmasters, my lord, their services were provincialized as headmaster. But in the higher secondary schools, my lord, the post of principal was not created at the time when the schools were provincialized. At the time when the schools were provincialized.
The candidate must have rendered at least 15 years of service as postgraduate teachers in any of the provincialized higher secondary schools. So,
But in respect of the inspector of schools, as we'll see, the post of principal is a, my lord, academic head of the school, my lord. The inspector of schools,
how is this in violation of Article 14?
my lord,
How does it violate Article 14?
these persons will never get an opportunity to.
Oh, no, why not? Once they acquire 15 years of service, then he will get.
My lord, what happened, my lord, the post of principal was not created at the time of provincialization of the school. Though the post of headmaster was created in the high schools, in high secondary schools, my lord, the post of principal was not created. Now they are creating the post. And if now the posts are created and the petitioners will be debarred from.
No, let us see what is your pleading here.
Yes, my lord.
Yes, Mr. Katalia, what is it?
Provision is clearly mentioned that 15 years is required from the date of provincialization. In fact, it is mentioned in the rule Roman 2, subclause 5, my lord. There is a clear.
Roman 2, subclause 5?
Yeah, my lord.
Rule
5, rule 5,
3, Roman 12, 3, 5, proviso.
Proviso, my lord.
12, 3, 5, proviso.
Proviso, my lord. There is a specific rule, my lord. Provided that the service and teaching experience acquired in a school during provincialized period shall be counted. The period rendered prior to provincialization shall not be counted. That's been mentioned clearly in the rule, my lord.
That is also under challenge, my lord.
Prior to provincial, they are in venture stage, my lord.
Because the
And
government.
mere hardship for a particular group of person does not make the rule violative of Article 14, my lord.
So who are these petitioners? Let us see. Some of them are 58, 56. Then there are 54, 49, 50, 51. So, so they are all, so where is the thing? What is wrong?
Well, that is why the petitioners are praying for invoking the provisions of Rule 33. Rule 33, the relaxation provision, under which they their qualification can be relaxed, my lord.
How is it? How is it arbitrary? I fail to understand how it's arbitrary.
Well, at the time when the schools were started, my lord, does the
How because you are born into the cadre. Only in 2013.
my lord, that is true, my lord. That is true. That is true. My lord, what happened, my lord? The initially,
These rules in 2008.
initially, my lord, due to shortage of colleges, my lord, the government, my lord, decided to upgrade the schools, but due to financial crunch, my lord, they would not upgrade the schools. And
Everyone, all these government servants, they cannot be promoted. So where is the discrimination?
my lord, in respect of the inspector, the post of inspector of schools and DEO, Assam Education Service, my lord, there, my lord, it doesn't say that they should work in a provincialized schools.
No. There's the question of provincialized. Provincialized means is basically a government. So it became a government school in 2013. Where's the question of you being considered as a government servant prior to the school being provincialized?
Well, I am not saying that I should be considered, my past services should be counted for, my lord,
It be
because I'm.
when you're not a government servant.
My lord, I'm working in the same capacity even
Maybe
from the
you're
date of
working as a
initial appointment.
you're working as a private teacher, private.
And due to
You are happy, you are lucky that the government has provincialized the school in 2013. You are enabled and you can become a government servant thereafter.
well, it is the government, my lord, who could not upgrade the schools. My lord, they prefer, my lord, they prefer a short adjournment, my lord.
No, no.
My lord, initially,
There's no.
morning also, my lord, I made a mention, my lord, for taking up the matter in the
You
next.
have submitted you see, you have got to submit a slip. Otherwise, what you do is by not submitting a slip, you make us read the file.
My lord, lawfully take
So
up
what-
matter on Friday next month.
No, we are ready today.
Coming Friday, my lord.
Ready today.
I could not prepare the matter.
You could not prepare, but you made us prepare. You could not prepare. You have filed the writ.
I'm sorry for that one.
You have filed the writ petition. How did you file it? By closing your eyes, you just dictated.
No, not that.
How did you do? With open eyes. You were the one who filed
Friday.
it.
If required, my lord, lawfully take up the matter as part of matter, my lord, on Friday, man. Coming Friday.
There's no case. There's no.
Friday, lawfully dismiss my
What, no?
also, my lord. I have no objection.
There's no case at all. How can your service as a private teacher be considered? Where is the discrimination? That 15 years is required for everybody. It is. Then how does it? Where is the question of arbitrariness?
My case is that for 15 years, I have the experience of more than 15 years. I have the experience of more than 15 years, but I do not have the experience in the provincialized school.
So what? That is, you're lucky that you were provincialized. You should have carried on being a private teacher in a private school.
Should I take up the matter on Friday, my lord?
Just file a case just like that, the rule. You've got to give some reasoning. There's no reasoning. How the rules are bad, nothing is there. We don't even have to exercise our grace cells there. Everything is so.
By then, my lord, I'll.
By then, no, we'll take you back if you want. You read by that time. We have to read this case way. Amongst all our other works.
Tomorrow, my lord, tomorrow, my lord.
Huh?
Tomorrow.
No. MFSC, we find no case. We just giving you time till 2:30 to come up and show us how it's arbitrary, how it's violative of Article 40. And not
For tomorrow only, my lord, I'm praying.
heard, we're discussing it.
Then at 2, my lord, I'll try, my lord.
Huh?
Then at 2, my lord, I'll try.
2:30.
2:30.
Two or two.
May I please, Your Lordship. The petitioner before your Lordship, they are working as Turner.
Huh?
Turner. They are working as Turner in the General Reserve Engineer Force, my lord. GRAPS, which is shortly known as GRAP, my lord, under the Border Road Organization at Tajpur, Your Lordship. My lord, they had the scope of promotion, a limited promotional avenue of 10%. 10% in the cadre of, my lord, in the next higher cadre of charge mechanic. 1982 rules, the amended 1996 rule provided this promotional opportunity, Your Lordship, to the petitioners. But now new recruitment rule has been introduced, my lord, in the year 2012.
So in the rules of 1982,
82 as well as the amended recruitment rule 1996, that provision of 10% was maintained.
10% promotional post. Only for turners.
Only for turners.
So,
Charge mechanic. Then, my lord, this scope of avenue of promotion, limited avenue of promotion, now taken away by 2012 recruitment rule. That is under challenge.
2012.
12 recruitment rules. And this is opposed to the law laid down by the Honorable Supreme Court in the case of.
So there is no promotional avenue for you.
For me.
No promotion.
No promotional. And there are strong recommendations. Annexure 5, Annexure 8, Annexure 9, strongly recommended by the department that there should be provided with at least some promotional avenue. Otherwise, they will retire as Turner, my lord, which is opposed to the law laid down by the Purushottam case, Food Corporation case, and other cases.
When were you appointed?
My lord, some of them are long before 2012 and some are after 2012.
Before 2012?
12 and after 2012.
When were you all appointed? Give me the date.
There are
Annexure 3 to the page 172 of the affidavit law.
$1996. Is it?
Yes.
2008. DOA is what? DOA means?
Date of appointment.
Date of appointment as Turner.
Yes. ENR.
Turner.
And what was the criteria for promotion? 82 rules and 96 rules?
My lord, some experience, 3 years experience is needed.
3 years experience.
Is it?
As Turner.
Turner.
That's nothing else.
Nothing. And we are 2 years diploma holders. Now only vehicle mechanic, they are also ITI 2 years diploma holders. Now only avenue is made in the new recruitment rule only for the vehicle mechanic. They are also 2 years ITI diploma holders. And we are also 2 years ITI diploma holders.
Well, mechanic.
Vehicle mechanic. They are now in the new recruitment rule,
Vehicle mechanic,
vehicle mechanic, they have been now,
in the 82 rules, their promotional post was what?
my lord, they are also entitled at that point of time.
Huh?
They are also entitled.
Also entitled as a charge mechanic.
Charge mechanic.
So vehicle mechanic could be promoted to charge mechanic.
Charge mechanic.
As per the 1982 and 1996 rules.
90s.
They also had 10%.
Yes, yes.
They also had 10%.
No, not 10%. Kuta. Out of 10%, they are also considered. But for Turner, it is 10%. For Turner, it is 10%.
For it is 10%.
10%.
And for this vehicle mechanic, they out of the 90%.
They are out of.
In the 90% they could be considered. And so now, with the 2012 rule, this vehicle mechanic.
We are ousted.
We are ousted, but
We are ousted.
they
Vehicle
can,
mechanic have been granted.
they can still become.
They can still be.
charge
become.
mechanic.
Yes, ma'am.
And the educational qualification is diploma.
Diploma holder, 2 years, diploma holders. My lord, even the divers, my lord, I have enclosed the scheme of divers.
Just a minute. Diploma holder 2 years in what field?
My lord?
In what field? Diploma holder in what?
Yes.
Electricity, civil, what? Or what do you mean by diploma holder? The computer application
No.
or what?
Turner trade is there, man.
And that trade.
Trade
But
is-
for mechanical, vehicle mechanic, what is the diploma? Diploma in what?
Diploma in, my lord, vehicle mechanic.
Vehicle mechanic. So, for Turner, you have got to have diploma in as a
2 years
turner.
diploma.
2 years diploma as a turner.
Turn. My lord, even the divers, that in the recommendation your lordship will find, the divers have been given 4,200 grade pay also by preparing a scheme. The department made 3 recommendations. None of the recommendations have been considered. Those 3 recommendations are there. The department itself made the recommendation. These recommendations are annexed 5.
Mr. Counsel, what has drivers got to do in this case?
No, I am saying, my lord, everyone, diver is not having any diploma or anything. They are only
They are a different
They are
class.
only matriculate, my lord. They are only matriculate. They are getting the promotional scope of 4,200.
Mr. Counsel, don't get excited. Don't get excited. You see, you do not expect a turner to drive a car. Okay, you don't expect a vehicle mechanic to drive a car. For that, there are drivers. So, drivers separate. Keep that out. You don't expect a driver,
My lord,
diploma holder.
with your lordship, only my contention is that even the divers, they are having matriculation. They are getting, by virtue of the scheme they have prepared in the department, they are getting the promotional scope up to the grade pay of 4,200. So, my lord, at least for this, and there are strong recommendations. Also, may I take to your lordship to the 3 recommendations given by the department. That is annexure
No,
5.
no, it's okay. Now the thing is that what was the reason, Mr. Counsel, please understand. Please try, let us have a two-way traffic. You see, you don't expect to only say something and we listen. We are trying to understand your case.
My lord, right.
Now, what was the reason for doing away with your promotional quota? According to you, why did the respondents do away with your promotional quota?
No valid reason has been assigned.
No reason given.
No valid reason has been assigned.
I'm asking you, I'm not questioning whether it's a valid reason or not. I'm asking whether there
Now-
was a reason.
No, my lord, no valid reason.
Okay, yes. What are the reason for doing away with the promotional quota?
As contended by the petitioner, that their promotional avenue is one of
Close.
in view of the new act rule. In fact, Government of India implemented the 2 schemes, the SCP and MSCP. In 1999, SCP scheme was continued. Thereafter, MSCP scheme was introduced subsequently. Accordingly, after 10 years, each and every employee, their scale will enhance. The promotional, they will get the salary as pay scale.
You see, this MACP scheme was there anyway, prior to the 2012 rules being enacted. So it was there anyway. But why are you doing away with the promotional avenue?
Malat, in view of this new Malat rule, Malat.
But
They are diploma holder, that not diploma, Malat, in Malat, not even the junior engineer, they are most probably ITI.
IT.
maybe.
As per new rule, Malat, the promotional revenue, Malat, for the ITI cadre is not there, Malat. In fact, Malat, what happened, here is the case, Malat, they themselves stated in their body of the petition, paragraph 18, they earlier approached the Honorable Delhi High Court. They withdraw the writ petition there. Malat, with a liberty, they will approach the authority to submit the application.
Okay.
They never, in their pleadings, they never approach the authority with any application to provide promotion, Malot. They only submitted certain RTI document, Malot, why promotion is not given. Malot, that kind of Malot, the Delhi High Court,
So is, yes,
this order is not annexed. I have the copy of the order. They withdraw, while withdrawing the order, Malot
Disclosed it.
paragraph 18.
We have
made a
disclosed
statement.
paragraph 18, we have disclosed it.
then you have disclosed, then why haven't you acted upon your
My lord,
undertaking?
There are
They
already,
approach
on our
the
petition already recommendation is there. On our petition already recommendation is there.
authority to approve.
Document look into,
That is the direction given by the High
no,
Court.
no, it is already recommended. The department has already recommended on our representation.
Para?
My lord, that I'll
in their statement regarding that.
Page 25.
The same petition.
My lord, page 111.
Yes. Yes, why didn't you file representation?
My lord, lordship, we have filed representation, it was recommended. And page, we filed recommendation, representation, and it was recommended. Annexure 8, page 111. Page 111.
Yes. No, Mr. Counsel.
And thereafter also recommendation, other recommendations are there. Other recommendations are there, my lord. A statement of case, they have forwarded it. Statement of case, page 116, Annexure 10. And that was forwarded, my lord, in 2019. 116.
Where is the representation which you find post December?
I think this one only.
Page 11. And that was very, third line. And then made it 116, my lord. That is the last recommendation made from the government. 116. Annexure 10, my lord. Justification also given, my lord. Page 116. Financial effect, conclusion, and recommendation. Page 117. And
Yes. You see, there was a promotional quota for them. Now that has been taken away by the 2012 rules. No doubt there is a MACP scheme, but that MACP scheme was applied and enforced even prior to the 2012 rules. It was there and they were being applied. Now you have taken away that promotional quota. Why? What is the reasoning given for taking away? What is the justification?
And my lord, as you-
Just a minute.
Right.
I'm asking him, not you. When we are asking things for your benefit, you keep on interjecting. Yes. Can you tell us? What was the basis for taking away the promotional quota? Every decision has to be backed by reasons. Otherwise, it can run foul of Article 14, being unreasonable, arbitrary. Nothing, no reason.
No.
Give me the citation.
What paragraph? 22, page 150 onwards.
150. 150.
150.
Yes.
DPC for various trade in department being conducted by the area by courts based on the present and.
Where are you reading?
Paragraph 22.
22, okay, yes.
As per economic sample calculation, the pay scale of each point were marked and placed with the reverse scale. The said recommendation was accepted by the government. After the implementation of the report, the government
Indian Ministry of Road Transport Highway, Water Roads Development. Order number 13 from 10. Issued orders for Maja redistribution of some trade department. As per said order, we promote pursue the training sales, sales mechanic, chairs, electrical superintendent, so on and so forth. Superintendent were merged with the registered as junior and senior. Moreover, the incumbent in the post of the charge mechanic having diploma were redesignated to the junior engineer, EM, and non-diploma persons were seek to keep their status until they were vested out or till they acquired higher qualification for getting further promotion. Based on the needs and situation, the government have amended the requirement to function role for various posts and as stated in preceding paragraph that the post of charge mechanic diploma were redesignated to the junior engineer and thereafter various recruitment and promotion rules were published. Being a work-oriented organization, maintenance of parts and machinery is of utmost importance, and therefore equipment mechanical posts were created, which is to be filled up 100% through promotion from the inspector category of vehicle mechanic. Furthermore, the present equipment and promotion rules were binding on all personnel serving in the department. The owner of the equipment and promotional rules cannot be altered or violated as per the rules and principles of automatic and individual sector. At present, there is no post of charge mechanic held by in the organization other than the charge mechanic non-diploma who were ordered to remain in their post till they were stepped up. After implementation of the cadre review, both PLC employee yearly. The post of charge mechanic has been redesignated as equipment mechanical by Government of India Ministry of Defence letter number 15 November 2016. After redesignation of the above post, no fresh equipment and promotion rules for the post of charge mechanic has been introduced. As such, seeking promotion which is not existing is not acceptable.
You see, as per this, there is no promotion to charge mechanic.
Well,
as per this page 152, the post charge mechanic is to be filled.
Recruitment rule and my lord 96 amended recruitment rule. That provision is there, my lord. 82 recruitment rule. May I take to
Just a minute. As per the 2012 rules, how is the post of charge mechanic to be filled? Charge mechanic, how is it to be filled?
yes, my lord.
That page 93.
Page 93, your lordship. Page 93, the recruitment rule started. And relevant page is, lordship will find, relevant page 96.
Yes.
Charge in the top, my lord.
Yeah.
Charge mechanic
Yeah.
and promotion, by promotion, vehicle mechanic with 8 years regular service in the grade. Where juniors engineers who have completed their qualifying or eligibility service are being considered for promotion, their seniors shall also be considered provided they are not short of requisite qualifying eligibility service by more than half of such qualification.
This is what rules?
This is the new rule, my lord. This is the new rule, which is implemented here. Here, my lord, only vehicle mechanic. And in 82 recruitment rule and 96 amended recruitment rule, 10% quota was maintained for us. That rule is there. 82 and 90.
Page,
my lord.
Page 44.
Page 44, your lordship. It is started from page 39, your lordship, relevant page is 43 charge mechanic. It is started from page 39 in lecture 1. Relevant page charge mechanic is 43 and this 10% quota is 45 in the bottom. Turner and machinist, 10%. And 45 in the middle member. And this was also maintained in 1996 also. 1996 rule is page 51. Page 51.
What about the submission made by the respondents council that you are entitled to MECP? That
My lord, MSCP also dealt with in the judgment I have given that this is a non-functional promotion. They will remain in the same case, only upgradation. That was dealt by the first case. It was dealt that it cannot be linked up with the accelerated promotion scheme.
Which paragraph?
My lord. My lord, may I first take your lordship para? I will come to chronologically, my lord. Para 9, page 3, my lord. I have given the presentation. Page 3, para 9 of the first judgment.
Yes.
Yes, I am reading it. Better. 9. Appellant is a state within the meaning of Article 12 of the Constitution of India. An employee of a state, although has no fundamental right of promotion, it is a right to be considered therefore. What is necessary is to provide an opportunity of advancement, promotion being a normal incidence of service. Thereafter, MJ Oji Hussain has been quoted. This court has on more than one occasion pointed out that provision for promotion increases efficiency of the public service, while stagnation reduces efficiency and makes the service ineffective. Promotion is thus a normal incidence of service. There too is no justification why, while similarly placed officers in other ministries would have the benefit of promotion, the non-medical A group scientists in establishment of Director General of Health Services would be deprived of such advantage. In a welfare state, it is necessary that there should be an efficient public service, and there it should have been obligation of the Ministry of Health to attend to the representation of the council and its members and provide promotional avenue for this category of officers. It is therefore necessary that on the model of the rules framed by the Ministry of Science and Technology, with such alteration as may be necessary, appropriate rules should be framed within 4 months from now, providing promotional avenue for the Group A category of scientists in the non-medical wing of the directorate. Then, my lord, para 11. The question also came up for consideration in Ujagar Print, etc. versus Union of India, AIR 1989, SC 1972, Council of Scientific, where it is often and said, and indeed, adroitly, an organization, public or private, does not hire a hand, but engages employees, a whole man. The position is recruited by an organization not just for a job, but for a whole career. One must therefore be given an opportunity to advance. This is the oldest and most important feature of the free enterprise system. The opportunity of advancement is a requirement for progress of any organization. It is an incentive for personnel development as well. Every management must provide realistic opportunities for promising employees to move upwards. This organization that fails to develop a satisfactory procedure for promotion is bound to pay a severe penalty in terms of administrative cost, misallocation of personnel, low morale, and ineffectual performance among both non-managerial employees and their supervisor. There cannot be any modern and management, much less any career planning, manpower development, management development, which is not related to a system of promotion. When employees are denied an opportunity, this is very important, my lord. When employees are denied an opportunity of promotion for long years, in this case 30 years, on the ground that he fell within a category of employee excluded from promotional prospect, the superior court will have the jurisdiction to issue necessary direction. If there is no channel of promotion in respect of a particular group of officers resulting in stagnation over the years, the court, though may not issue any direction as to in which manner a scheme should be formulated or by reason thereof interfere with the operation of existing channel of promotion to the officers working in different departments and officers of the government, but the jurisdiction to issue direction to make a scheme cannot be denied to a superior court of the country. My lord, para 19, then my lord, I am coming to para 19. Admittedly, a direction was issued by the Andhra Pradesh High Court to the appellant for framing a scheme for medical officers and implemented. So far as contention of the learned counsel that the cadre of assistant engineer is not important for the appellant for providing promotional avenue to them is concerned, the same is stated to be rejected. We fail to understand how the cadre of medical officers would be important as like the respondent. They also do not contribute towards the main functions of the appellant. Such a plea, even otherwise, is wholly untenable. An employee is an employee. How the employees would be structured is undoubtedly within the realm of the statutory authority, but by the reason thereof, it cannot tinker with their essential fundamental rights. Para 21, my lord. So far as introduction of grant of selection grade is concerned, the same does not provide for a promotional scheme. It is available to a limited number of employees. By reason thereof, a promotional scheme cannot be said to have been framed. The scheme of, here my lord, the scheme of accelerated career progression. My friend was referring MSCP, SCP scheme. That was also dealt.
The accelerated career progression is not MSCP. This is different.
No, SCP, this is SCP and MSCP. These are SCP and MSCP. Accelerated career. SCP. Yes, madam. It is modified. That was modified in 2009.
So where are you reading MSCP scheme into this accelerated?
No, accelerated career progression scheme.
This is a career progression. This is not a MSCP scheme.
No, SCP scheme. SCP then. It is SCP scheme.
Is it?
Yes. It is SCP scheme, and subsequently after 6 pay commission recommendation, it was modified. Then it is called MSCP scheme. Earlier it was 12 years and 24 years.
No. It's a different. You're confusing assured career progression scheme with accelerated. You're making you're confused.
SCP assured.
This is something else. Accelerated is different.
But my lord,
Accelerated, you know the meaning of accelerate. When you press the accelerator of you go fast. So if there is a promotion scheme, if you press the accelerator, your promotion will be faster. That is not, this what we are concerned with the assured career progression scheme. That you are assured of progression by way of your structure going up. Financial benefit. So don't, you're confused.
My lord, sorry, my lord.
Accelerated is different.
My lord, even then SCP and MSCP is non-functional. It is not promotional.
Whatever it is.
No, non-functional. This is the financial benefit is given. LDC need to work in LDC cadre, even after getting the higher pay scheme. Higher pay scheme. The next judgment your lordship will find. This is my lord A. Satyanarayana versus S. Purushottama of the Honorable Supreme Court. Page 7, it is started. The relevant page is 15. Relevant page 15, paragraph 27. To the said extent, the rule maintain a birthmark which runs counter to the decision of this court, Darka Prasad versus Union of India and others. Although mere a chance of promotion is not a fundamental right, but right to be considered, therefore, is. In that view of the matter, any policy whereby all promotion avenue to be promoted in respect of a category of employees for all time to come cannot be nullified, and the same would be hit by Article 16 of the Constitution of India. There are 27, my lord, page 15.
Yes.
Then, my lord, page 18, Council of Scientific and Industrial Research versus KGS Bhatt and others. Their judgment was quoted, my lord, lastly, page 21. Page 21, in the bottom, para 14 and 15. In the instant case, he has already noticed that respondent 1 has suffered and stagnated for about 20 years in the same scale.
In the same scale.
In the same scale.
In the same
Due
scale,
to
but out
defective
here.
promotional policy. Due to defective promotional policy.
Correct, but out here, you're getting MACP. So your scale is going to change.
My lord, promotional cannot be, your lordship, promotional avenue must be there. In all the cases I have enclosed here, promotional avenue must be there. And there was a strong recommendation.
If promotion avenue is always there.
There is no, it is totally, my lord, taken away. Taken away.
But supposing promotional avenue is there, but they do not get promoted, then they are compensated by way of the assured career progression scheme.
My lord, this is a non-functional.
So what?
Non-functional.
So what? If it's functional or non-functional,
non-functional,
how does it matter?
And they have taken,
please.
Only vehicle mechanic is, even then, vehicle mechanic is remain. They have been provided with the promotional opportunity. They have been provided with the promotional rules. Then, my lord, Annexure 22, page 22, OZ Hussain versus Union of India.
Yes.
It is page 24 relevant, para 7 and 8 I am reading. This court has on more than one occasion pointed out that provision of promotion for increases efficiency of the public service, while stagnation reduces efficiency and makes the service ineffective. Promotion is thus a normal incidence of service. There too is no justification why, while similarly placed officers in other ministries would have the benefit of promotion, the non-medical group A scientist in the establishment of the Director General of Services would be deprived of such advantage. In such a welfare state, it is necessary that there should be an efficient public service, and therefore it should have been the obligation of the Ministry of Health to attend the representation of the council and its members and provide promotional revenue for this category of officers. Here, my lord, our case was strongly recommended. At least 3 annexures I have enclosed. By the department itself recommended 3, my lord, they have strongly recommended to the government. It is therefore necessary that on the model rules framed by the Ministry of Science and Technology, with such alteration as may be necessary, appropriate rules should be framed within 4 months from now, providing promotional revenue of A category scientist. The writ petition is allowed with the following direction. Within 4 months from today, the Ministry of Health and Family Welfare of the Union of India shall frame a set of appropriate rules in inter alia, providing suitable promotional avenue for Group A scientists and the non-knowing of the establishment of the Director General of Health Services. My lord, State of Tripura versus K.K. Rai, page 26. It is also Honorable Supreme Court judgment. There are 8 I am reading, my lord. The learned counsel appearing for the appellant is is maintained that after that period.
How can you pay two promotions? Either you promote him, payment will be different.
Yes, that may be different. That may be different.
Huh? Yeah. I think it's a grant of giving a higher pay scale.
No, two promotions, Your Lordship.
You see,
We paid two promotions in the next higher scale.
you please read para 7, 8, and 9 together. You do not read one thing as you see, the Supreme Court also sometimes there is a.
No, I got your point. Apparently, Melody, it appears, but it appears. Apparently, I also, but finally it says that it should be
How can you
promotion.
how can you pay two promotions?
Two promotions.
Please understand, when you promote someone, do you say that please pay him two promotions, or you say you promote him? When a person is going to be promoted,
Leaving aside this judgment, my
you
lord,
say that you pay him two promotions.
even the other judgment, Your Lordship will find.
Mr. Counsel, the only problem with you is you're not listening, you're not trying to listen, and you just want to say what's in your mind, that's all. So we will
My
allow
humble
from
submission,
now on.
I mean, my humble submission.
That you're now also you're interrupting. You're now also you're interrupting. So for the last time, I'm going to try to communicate with you. After this, I'm going to listen. No more questions to you. I'm going to decide. We're going to decide without asking for any clarifications from you. So please be careful. Yes.
My lord, the last judgment, I'm saying,
Yes.
page 34.
Yes.
Chandraprakash Madhav Rao Dauda, Bharat Union of India. And the relevant page is page 50, my lord.
Tara?
Para 59, 60 and 61. My lord, in the recruitment rule, now they have made a change that 3 years diploma is required. 3 years diploma is required in the new recruitment rule. Now it says, if some employees initially recruited with lesser qualification, that will not stand on their way in getting the promotion in future course, even if the educational qualification is changed. Para 59, I am reading it. To put it in a nutshell, the change in the essential qualification made in 1990 or 1998, or the additional functions now required to be performed by the applicants, could not retrospectively affect the initial recruitment of the applicants as data processing.
That is a different issue altogether. That's a different.
No, my lord, here they said that even though now in the new recruitment rule, 3 years diploma have been introduced, that will not change those who have been recruited at that point of time. This future amendment of the recruitment rule or addition of the enhancement of the educational qualification should not be applied in their case to the employees who are already in service. That is the interpretation. I am reading it.
You mean to say that the unamended rules would apply to you?
Yes, that is the meaning.
There is a judgment of Justice bench, 5 judges bench, led by Justice U. Lalit, which had held that the judgment of that YV, what is that? YV
Ranja.
Rangaya.
YV Rangaya. That was
1983.
That was amended.
That is a bad law. Then YV Rangaya says what? That the vacancies that occurred during the applicability of the unamended rules would have to be filled up as per the unamended rules.
Yes,
but the Supreme Court, after 42 years, have held that that is a bad law.
That is a bad law. After
your case goes, this case goes.
No, my lord, here your lordship will find, at least your lordship will find in the first case after 20, 30 years, in all other cases, that the promotional avenue cannot be curtailed.
Mr. Basically, the Supreme Court has held that the state can change their rules for recruitment or for promotion also.
Here cannot take away the promotion.
Where is your right?
My lord, that has been in the first case.
Unless you see, that is what YV Rangaya's case had said, that if you are governed, if you could be considered as per the unamended rule, if you came into the zone of consideration as per the unamended rule, then your case for promotion would be considered as per the unamended rule, even if a new rule had come in the meantime. Supreme Court in 2 years back, in 23, 5 years,
State of Himachal.
State of Himachal Pradesh, Raj something.
Versus Rajesh. Versus Rajesh.
Maybe, yes, maybe.
2022.
In that case, it has held that no, that is a bad law. If there is a new rule amended, if the rule has been amended, the vacancies, even if it occurred during the applicability of the unamended rules, would have to be filled up as per the amended rule.
Well, here your lordship will find. Here your lordship will find after 20 to 30
You see,
years.
don't go into that aspect. That is not the issue. Your issue is something else. Do not go into an issue which is not an issue here. Your issue is that you had a promotional avenue that has been taken away.
That is exactly my case.
That is your case.
And my lord, lordship may look into the recommendation. Lordship may look into the recommendation. Lordship, annexure 5, your lordship, page 90 of my writ petition.
Yes, page 90 is of 22/9/2010.
10, my lord.
Then where is the other recommendation?
Other recommendation your lordship will find page 1111. Other recommendation. Page 1111. Chief engineer has recommended page 1111, my lord, on our representation. And that has not been decided by the government. Page 1111, annexure A.
Where is the third one?
My lord, then next your lordship will find. Third one is page 116, annexure 10. This is a justification, introduction, everything is given. Page 116. Annexure 10, my lord.
What is the, okay. 11/8.
116, lordship. Got it. Last para 117, my lord. Para 4.
You see, your first page 90 is not applicable for the simple reason that that recommendation had been made in 2010
My lord.
prior to the amendment of
that-
the rules in 2007. Then
But these are, my lord, these are latest latest recommendation.
that is the opinion of an authority. That's all.
No, they have been recommended. The government has not decided anything till now. Government has not decided.
So yes. Now you see, there are two questions that we want to ask you. First of all, your judgments are all prior to 2009. What is the law subsequent to 2009 or 10? What is the law now? The latest judgment.
Promotional revenue, even, my lord, in the case.
You know, have you read any judgments after 2008?
Well, I'll try to place your lordship. I'll try to place your lordship.
That is one.
I'll place.
You see,
I'll place.
law is changing all the time. Number two issue is with regard to this ACP scheme. Now, when you read the state of Tripura, the case of state of Tripura versus KK Roy, out there what has happened was, since no promotion for avenue was there, the Supreme Court had directed that the petitioners should be given the ACP. It did not say pay promotion. We are reading it wrong. When you read the entire the earlier paragraphs, it becomes very clear that since Tripura did not have an ACP scheme like the other states in India, Supreme Court had directed that the ACP scheme, not the ACP, the pay scale of 2 posts higher than what that petitioner was holding should be given to him. So it amounted to ACP scheme. No, please read. You have not read it. Please read this page. Where is that state of Tripura? That page.
It is apparently what your lordship is saying. This is also, I was also under the same impression. But finally, my lord, finally given that 2 promotion should be given. Promotion means. What was it to do that?
At page 28.
28.
You come to para 6. Para 6 at page 28 you come. You come 1, 2, 3, 4, 5, 6, 7, 8. Up to the 8th line, it starts from it is not disputed. Please read from there. It is not disputed. On the top, page 28. It is not disputed. Please read loud so that we can all hear.
Yes. It is not disputed that the other states in India, Union of India, having regard to the recommendation made in this behalf by the Pay Commission, introduced this scheme of assured career progression in terms whereof the incumbent of a post, if not promoted within a period of 12 years, is granted one higher scale of pay and another upon completion of 24 years. If in the meanwhile He had not been promoted despite existence of promotional avenue. Despite existence of promotional avenue. When questioned, the learned counsel appearing on behalf of the appellant even could not point out that the state of Tripura has introduced such a scheme. We wonder as to why such a scheme was not introduced by the appellant like the other states in India and what impeded it from doing so. Promotion being a condition of service and having regard to the requirement thereof, as has been pointed out by this court in the decision referred to herein before, it was expected that the appellant should have followed the said principle. We are thus of the opinion that the respondent herein at least entitled to grant 2 higher grades, one upon expiry of the period of 12 years from the date of his joining of the service and other upon expiry of 24 years thereof. The learned counsel for appearing for the appellant is however correct in the submission that the High Court in exercise of jurisdiction under Article 226 could have issued a writ or in the nature of mandamus directing the appellant hearing to grant a scale of pay which would be equivalent to grade 2 or grade 1 of the judicial service of the state. For the reasons aforementioned, we direct the respondent herein be paid 2 promotions. So my lord.
Please continue reading. Please continue reading.
Promotion in service. This appeal is disposed of with the aforementioned reaction.
Slowly, please read. For the reasons
For the reasons aforementioned, we direct the response.
Yes, herein. So please, you are only reading.
The respondent herein be paid 2 promotions.
Continue reading.
In the next higher scale of pay upon his completion of 12 years and
You cannot pay 2 promotions. It says here, in the next higher scale of pay.
in my humble submission, my lord, even this judgment also take care of promotion. This judgment also taken care of promotion.
No, you're not understood. It basically states that since there is no promotional post as on date, but because he has not been promoted for such a long time, and though the assured ACP scheme has not been made by the state of Tripura, he should be given the ACP scheme.
My lord, even
He should be given the next higher scale, pay scale of grade 1 or grade 2, even though the ACP scheme is not there in Tripura. That's what it is.
My lord, I'll try to find out.
So the question is whether the question that we're asking is whether if there is no promotional avenue, would an ACP scheme take care of the issue of there being no promotional avenue?
In one of the judgments, right now I cannot place it. One of the judgments, this was distinguished. So far I remember, my lord. I have come across that SCP and MACP, these are stand on a different footing. There is the judgment. So far I remember, my lord. I cannot say right now. And even in spite of that, my lord, even your lordship will find that there are strong recommendations and they have not taken any action till now. Any action till now. Any action. Favorite school technical. Favorite skill. Favorite skill.
There is another thing, Mr. Counsel. Now, when you read the affidavit of the respondent, it appears that the charge mechanic, your promotional post, earlier promotional post, has been amalgamated with various other posts. Correct? Now, so even if we were to say that there should be a promotional avenue to the post, to the new post, to the new designated post of those amalgamated posts, your quota might be lessened from 10% to I do not know, whatever the authorities say, because for the simple reason, charge mechanic and other few other posts have been amalgamated. So you cannot have 10% of that post.
It may not be.
It may not be.
May not be.
They will decide
They will have to.
the quota, the
Yes.
appropriate
That is there.
have to be decided by
That is
them.
there. That is there.
That is there.
That is there. And my lord, one thing I like to show you, Lordship, to impress upon your Lordship, rather, page 97, the same department, Border Road Organization, page 97, Annexure 7, your Lordship,
Page 97.
of my writ petition.
Yes, 97.
Here, my lord, even for the divers, we are 2 years diploma holders. Divers are not diploma holders.
They are a different footing.
Different footing, but they have made promotional avenue up to 4,200 grade pay.
Mr. Counsel, you are a different class altogether.
No,
They
they
are
are
a
making,
different
this
class.
same department made my lord, this is the notification, they have made a rule
Huh?
for promotion,
So-
promotional avenue.
So,
So I'm saying, my lord, they are making for other posts, not for the
how does it?
Dana.
You are a different class. There's no
Dana.
question of discrimination. There's no question of.
Yeah, they have given, my lord, and the recommendation also, in the recommendation itself, they says, in the recommendation, they says, my lord, their departmental officer, chief engineer says, you make a, to the government, make a promotional scheme like the divers. Make a promotional scheme like the divers.
Okay, that vehicle mechanic,
Right.
now they can be promoted to that newly amalgamated post.
Yes, ma'am. But not us.
Earlier they had how much? They out of the 90% they were the feeder post.
Yeah,
So now also they are in the feeder.
they are in.
And but the diploma will be different. Their diploma will be different. Your diploma and their diploma will be
Earlier
different.
it was my given, and some of the earlier,
That does not cut.
by virtue of the earlier promotional quota, some of the turner are who are promoted as charge mechanic, they are still working, my lord. And they have been deprived of by granting scale of pay.
You see, you please don't go into other aspects. Go into your line only. Otherwise,
My
when you go into other drivers and other mechanics, then you're bringing into your argument other classifications. And there the issue of discrimination of different persons, it does not cut much ice as per the law laid down. It's different. Even persons holding similar name posts in various departments. Say, so there is a civil engineer in the health department, civil engineer in the PWD. It's totally different. So out here, in same department, in your case, the same department, but different classes of persons. Very different.
But our humble prayer, your lordship.
Yes, when you are ahead in the race, sometimes you should keep sharp.
My lord,
When you are ahead in the race, you don't have to keep on saying something. There are times when you should keep quiet. Or you want to carry on saying something.
no, only my obliging.
There are certain ways to do things. You don't have to keep on trying to justify all the time. We're not saying we are the masters in law. But that same adage applies to you also. So sometimes it's better to just keep quiet and accept certain things that are there. Anyway, yes. So it appears that there is no justification for. You have talked only about amalgamating the promotional post.
Mal.
You have not given any reasons why the petitioner cannot be promoted to the newly amalgamated post.
While pointed out the new merger of the post, annex of 178. I mentioned it in the.
178, yes.
13 made on 10 law.
Huh?
13, that is a communication from the undersecretary of the government.
Yes.
178 law.
Yes, 178.
115.
Yes.
Other of the group B post, general reserve, letter, first of the bit, this one.
All right, very good. They have been amalgamated, so what? Now, where have you said that these persons do not have the competency to work in the newly amalgamated post? If a turner can be promoted to the post of charge mechanic, and that charge mechanic post has been amalgamated with others, where is your finding or where is your discussion to the effect that the turner does not have the wherewithal to work in the newly amalgamated post, or competency to work in the newly amalgamated post? There's nothing.
In our context in paragraph 22, page 51, that we discuss everything. Mala.
Page 51. Yes, sure.
Just now, sometimes ago, I read out the paragraph.
Yes. No, we're trying to understand.
Try to the middle portion, moreover the income and
Page
page
51.
151. Mala.
Huh?
151.
Yes. Yes.
Moreover, second paragraph.
Yes.
Moreover, the incumbent the post of charge mechanic having diploma were indesignated to junior engineer union and no diploma personnel were said to keep their status until they are vested out or till they acquire higher qualification for getting further promotion. Based on the needs of the situation, the department has amended the recruitment promotion law of various posts and as stated in preceding paragraphs and above, the post of charge mechanic diploma holder was redesignated to junior engineer union and thereafter fresh recruitment and promotion rules were published. Being a work-oriented organization, maintenance and plans and machinery is of utmost importance, and therefore the equipment mechanical post was created, which to be full of 100% to promotion from its feeder category of vehicle mechanic. The present equipment and promotional rules.
So vehicle mechanic is allowed promotion. So it's a promotion post. Now, where have you said that these turners cannot do the work of this newly amalgamated post?
In the paragraph itself, we stated they are wasted out.
No, Mr. Counsel.
Mr.
Counsel, no, please read. And non-diploma personnel were said to keep their status until they are wasted out. For non-diploma persons, you can waste them out.
Wow.
The petitioner's case is that they are diploma holders. You are talking about non-diploma holders.
Yes, Mala.
Their case is that they are diploma holders. So this will continue.
Mala.
Diploma holders, you waste them out.
So from my understanding, Mala.
Yes, we are going to follow your understanding only. You waste them out. We are going to say you waste them out as per this paragraph.
Mala.
The non-diploma holders. But the diploma holders, you should give them an avenue of promotion. Yes, right. Heard, Mr.
M2.
May I just throw lots point of one thing. Well, here, already your lordships gone through it, well, I placed it for lordships. They repeatedly approached the courts, one after another.
Correct.
Earlier,
Correct.
two occasions they withdrawn the writ petition.
Correct.
Here also in the,
Correct.
this along the courts. As well as the Delhi High Court also. At time of withdrawal, there is a suggestion that they will oppose the authority. Our pleadings,
They have approached
no, our pleading, specific pleadings is that.
specific meeting, you have not
That is a
denied.
recommendation, merely recommendation.
No, no.
They never, nowhere they are saying that they oppose pursuant to that, amount.
Mr. Council, come to page.
They
111.
submitted the
Please
RTI.
come to page 111. Please come to page 111.
That is the recommendation made by one
Mr.
of the.
Council, please
No, no.
read. Please see.
No,
Please come to the second, please read the first three lines. So and so
application, on
have
application.
submitted application dated 16 September 2015. And Delhi High Court order is of 2014. What are you talking about? You don't even read the file. Right. Heard, Mr.
M. Chanda.
M. Chanda, learned counsel for the petitioners. Also heard Mr. UK Goswami, learned CGC. The petitioner have prayed for for setting aside the impugned notification dated 3/10/2012. This is a notification at 3/12/2012. Your prayer is not correct. You want to set aside the entire rule.
And alternative pair B, my lord.
Okay. Okay, that's right. 2012. By which the Ministry of Road Transport and Highways, Border Roads Development Board, General Reserve Engineer Force, Border Roads Organization, Junior Engineer, Electrical and Mechanical, close, Group B Post, Recruitment Rules 2012. Hereinafter referred to as the 2012 rule, have been enacted. Under the proviso to Article 309 of the Constitution. This is at page 93. The further prayer of the petitioner is to frame service rules. Is to frame service rules in consonance with the General Reserve Engineer Force Group C and Group D recruitment rule, 1982. Hereinafter referred to as the 1982 rule, and the amended recruitment and promotion rule, 1996. Hereinafter referred to as the 1990. You should have read your prayer. You should have asked for setting aside that particular rule.
Yes, that is,
Which rule is the one affecting you?
it's 2012.
2002. Not the entire rule. Only that. Where is the
That portion, my lord.
that the relevant rule?
Relevant portion is. It is page 93. Rule is page 93 and relevant portion your lordship will find 96, my lord. Charge mechanic.
This is rule 8. What rule is this?
2012 recruitment rules. This is part charge mechanic. Falls in page 96, my lord.
Huh?
Charge mechanic. Charge mechanic, page 96. Page 96 in the top left hand side.
Next, the petitioners, whatever, the petitioners council, the petitioners case is that the 2012 rules should be set aside in so far as the promotional avenue of the petitioners who are turners, who are employed as turners. What do I say? Turners, have been extinguished for being promoted to the promotional post of charge mechanic. Which has now been redesignated as 151. 50. Redesignated as junior engineer bracket E&M. Right. Next part. The petitioner's case is that in terms of the 1982 and 1996 rule, the turners employed under the Border Roads Organization, bracket BRO, in short, very close, were having a 10% promotional quota to the post of charge mechanic. On the other hand, the petitioners who were turners had the educational qualification of diploma in 2 years diploma in
Turner trade.
in Turner
Trade.
Turner trade. TURNER. Turner. The vehicle mechanics who also had the who had the educational qualification of 2 years diploma in vehicle what?
Vehicle mechanic.
Vehicle mechanic were could be promoted to the post of to the remaining 90% quota of 90%, 90% to the, no, to the remaining, to the post of, to the remaining, post of, charge mechanic. However, with the coming into force of the 2012 rule, the promotional, the 10% promotional quota of the of turners for promotion to the post of charge mechanic was done away with. The petitioners count, next part, the petitioners count is subject that promotion being a condition of service, comma, the respondents could not have taken away the promotional avenue of the petition without giving any justifiable reasons for the same. That's your thing. He also submits that the 1982 and where is the repealing clause in this new thing in this 1982? No, where is the repealing clause in this 2012 rules? The problem is you give things in half. You had the full rules, 2012 rules in your hand. How do we know that the 82 rules and the 1996 rules are repealed? First of all, your prayer is not also not correct. You don't have documents, at least in your own file.
It's 19. 20.
Where is the repealing clause?
Repealing clause it was there. Repealing clause.
This is the, we think it's. Page 93. Because this only talks of the 19, actually this talks of 1982.
Yes, sir.
It doesn't talk of the 1990,
Amended rule, it does not talk.
does not talk. 96 there. Okay, this side. So whatever I said. Forget it. We'll just use it. We also submit that the 1982 rule was superseded by the 2012. Next part. Mr. UK Goswami, the learned CDC. On the other hand, submit that that there was no infirmity with the doing away with the promotional avenue of the petitioners to the post of charge mechanic by way of the 2012 route. In view of the fact that the post of charge mechanic who were having diplomas was redesignated as junior engineer bracket ENM. So where is the amalgamation? There's no amalgamation of different posts. It's only a redesignation. Mr. Goswami, it's only a redesignation. There's no amalgamation of
5 base 178 merger and redesignation of the grade
70. Okay.
B post to general.
Okay, what have I said? As the charge mechanic bracket diploma holder post was merged with various other posts such as superintendent ENM-1, superintendent EM-2 diploma holder bracket and charge electrician bracket diploma holder. While letter number F number full stop BRDB /166/2010/GE-1 dated 13/5/2010 issued by the Undersecretary to the Government of India, Border Roads Development Board, Ministry of Road Transport and Highways, Government of India. Page 170. Mr. UK Goswami submits that in view of the incumbents in the post of charge mechanic having diplomas being redesignated as JE bracket ENM, non-diploma personnel were to keep their status until they were wasted out or till they acquired higher qualification for getting further promotion. Based on the needs and the situation in hand, the 2012 rules were promulgated. And being a work-oriented organization and BRO being a work-oriented organization, maintenance of plants and machinery was of utmost importance. Thus, the redesignated post which was created was to be filled up through 100% promotion from the feeder category of vehicle mechanic. As there is no post of charge mechanic in view of the above reason in the BRO, other than charge mechanic bracket non-diploma, who are to be wasted out, comma. There was no promotional avenue for the petitioner to the post of charge mechanic bracket diploma. He further submits that the post of charge mechanic has been redesignated as equipment mechanic bracket mechanic by Government of India, Ministry of Defence, BRDB letter number BRDB/02/21/2010/G volume dot Roman 2 dated 15/11/2016. Yeah, Mr. Goswami, you have said that they are JENM. At the same time, you have said that they are equipment mechanical at page 151. What is their exact name? Page 151, last line. The post of charge mechanic. Now this charge mechanic in the second last line, page 151. Is it diploma holders or non-diploma holders?
Well, as for this statement, Malak, there is no diploma holder, Malak, at present. All are non-diploma.
So
That is why they have to waste it out, Malak.
No, so the remaining, so you mean to say that the charge mechanic non-diploma, now they are called equipment mechanic, is it?
Malak.
Is it?
Malak.
And they have to be wasted up.
Malak.
Huh. Next. Next, Mr. Yuki Goswami, learner series in submit that even though no promotional avenue exists for the petitioner in view of the 2012, the petitioners are not deprived of any financial benefit due to not having any promotional avenue. In as much as they are covered under the Assured Career Progression / Modified Assured Career Progression Scheme, which is granted to each and every turner on completion of 10/20/30 years of regular service as per the policy in vogue in the BR. That's your case, I think. We have heard the learned counsel for the panel. As can be seen from the submissions made by the counsel for the party and the pleadings, the petitioners who are turners having 2 years diploma as turners had a 10% promotional avenue, 10% quota for promotion to the post of charge mechanic in terms of the 1982 rule. For promotion to the post of charge mechanic, a turner had to have 3 years of regular service Is it?
3 years.
3 years regular service. As turner.
Yes.
For those turners who could not be promoted due to shortage of vacancies in the post, in their quota of 10% to the post of charge mechanic, comma. The turners were given the benefit of the MACP scheme in terms of the MACP policy applied by the BR. Even during the applicability of the 1982. However, with the coming into force of the 2012, the promotional, the 10% promotional avenue of the petitioner has been taken away, without any justification being provided by the respondent. Next one. Though it is the case of the respondents that the post of charge mechanic had been amalgamated / merged with 3 other posts, such as superintendent ENM-1, superintendent ENM-2 bracket diploma holder, and charge electrician bracket diploma holder, which was redesignated as JE bracket ENM, and non-diploma personnel were to be wasted out. The fact remains that the petitioners herein are having 2 years diploma holders as turner. There is nothing to indicate that a decision has been made by the respondent authority that turners having 2 years diploma are not competent to do the job of charge mechanic, which has been redesignated as JE bracket ENM. Next paragraph. In the case of Food Corporation of India and others versus Parashottam Das Bansal and others, reported in two 2008 5 SCC 100, the Supreme Court had held that an employee of a state has the right to be considered for promotion, although he has no fundamental right of promotion. It further held that promotion being a normal incident of service, it was necessary for the state within the meaning of Article 12 of the Constitution to provide an opportunity of advancement. Provide an opportunity for advancement, huh? Good stuff. It further held that if there is no channel of promotion in respect of a particular group of officers, resulting in stagnation over the years, the court can issue a direction to the government to make a scheme for promotion of those officers. Good stuff. Then you take that is also there. Next. In the case of A. Satya Narayana and others versus S. Purushottam and others, is all there. 2008, 5 SEC 416. The Supreme Court held that Purushottam well, the Supreme Court relied upon another of its judgment in Dwarka Prasad and others versus Union of India and others, reported in AIR 2003 SC 2971, where it held that any policy whereby all promotional avenues to be promoted in respect of a category of employees for all time cannot be nullified, as the same would be hit by Article 16 of the Constitution of India. Next paragraph. In the case of Council for Scientific and Industrial Research and others versus KGS Bhatt and others, reported in 1989, 4 SEC 635, the Supreme Court held But the Supreme Court declined to interfere with the decision of the learned tribunal, wherein it had been slightly confusing. है ना? Cut this, cut this, cut this. In the case of O.S. Hussain versus Union of India and others, reported in 1990, Supply SCC 688, the Supreme Court held that the provision of promotion increases efficiency of public service, comma, while stagnation reduces efficiency and makes the service ineffective. Full stop. It thus held that promotion was thus a normal incidence of service. Para 7 of the said judgment is reproduced herein below as follows. Take it. In the case of State of Tripura and others versus K.K. Roy, 2004, 9 SCC 65. The Supreme Court held that, had directed the state of Tripura to pay to the petitioner, to the respondent therein, the next two higher scales of pay on completion of 12 years and 24 and completion of 24 years of service. As the respondent had not been, if the respondent was not promoted within, 24 years of service, even though the state of Tripura did not have an ACP/MACP scheme. In view of the fact that the respondent had not been promoted, despite the existence of promotion. Next. On a bare reading of the above judgments of the Supreme Court, it is quite apparent that the state is required to provide promotional avenues to its employees. So that the denial of the same does not run foul of Article 16 of the Constitution. Full stop. We have noticed that the petitioners had earlier approached the Delhi High Court via WPC 9025/2014, which was allowed to be withdrawn via order dated 19/12/2014, to enable the petitioners to file a representation to the respondent for providing promotional avenue to the petition. In pursuance to, in pursuance to the said order dated 9/12/2014, passed in WPC 9025/2014, the petitioners had submitted a representation dated 16/9/2015 to the respondent seeking promotion to the next higher post. The chief engineer, bracket P, BEACON, beacon, made a recommendation to the authorities, to the higher authority, for considering the representation of the petitioners in the ensuing chief engineers conference for deliberation. Thereafter, the what is this para 116? What is this? Who is this person? Para 117. Who is this person? Para 117. Who is he?
It's page 117.
Yes.
Sridhar Chaudhary, Colonel Admin Manager.
Yes. Where? Admin manager? Where? Where? In KFC? McDonald's? Where? Administration manager? Where?
BRO, man.
From where do you get that BRO?
Page 116, my lord. Statement of case for providing promotion in Poda Road organization.
BRO.
What have you written regarding annexure 10? Let me see.
Well, that is a type out copy of 118, Malot. It is not legible, but in the bottom part, it's care of 99 APO. The organization of the BRO, it's under the
BRO. First up, thereafter, the prayer of the petitioners was apparently also considered by the Colonel ADM manager, BRO, on 11/8/2019, where it was recommended that promotion avenue should be provided not only to the petitioners who are turners, but also to machinists, MACHI, NISTS, machinists, painters, welders, carpenters, etc. However, no decision has been made by the respondent authorities till date. So we ask them to consider their thing, or we should ask them to take a decision. Or we direct.
Consider.
Huh?
Your lordship may direct them consider. Direct them to consider.
Gustav, next para. Next para. Due to the reasons stated above, we are of the view that the respondents should take a decision with regard to the petitioner's prayer for giving promotional avenue to the turners in the newly redesignated post of JE bracket ENF. Turners, you make it bracket diploma holders. This is due to the fact that the turners bracket diploma holders had a promotional avenue in terms of the 1982 rules, and no reason has been provided as to why turners bracket diploma holders cannot be promoted to the newly designated, to the redesignated post of JE bracket ENF, where the promotional post of the petitioner, that is charge mechanic, is included. Charge mechanic diploma is included. Gustav. Anything else? Huh? In view of the direction passed by us to the respondents. No, before that, right? The respondent should take a decision on the question of providing promotional avenue to the petitioner within a period of 3 months. 3 months from the date of receipt of a certified copy of this order. In view of the above, in view of the fact that we are not deciding the case on merits, you see, one thing is that because your prayer is slightly thing.
Only for consideration, your lordship.
Yeah, we'll just know that.
Consideration should be decided within a period of 3 months, your lordship.
That
will not.
Because there is some.
On merit, your lordship, if your lordship
Yes,
says something
the
merit,
prayer is-
they will
Yes, the prayer.
take it otherwise.
Hello.
We'll add it later. Okay.
Only if on merit, if your lordship thinks, then they will take otherwise.
Yes.
obliged.
Yeah, so we'll leave it at this. We'll just make correction here
My-
and there. Okay.
My lord, deeply obliged.
That it patients
Deeply obliged.
accordingly disposed of. Stated, subject to the, as, uh, 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 in terms of the order passing the main appeal, so that there is no double. Otherwise, they won't pay. Yeah, as we don't require stay. Ah, yes.
My lord, before proceeding with the matter, my lord, Mr. May kindly see the background of appointment of the petitioners. On the what background they are appointed, man. Paragraph 3 of my petition, my lord.
Yes.
May I read, my lord? That the petition will state that due to increasing numbers of students who passed out SSLC examination, the existing high secondary schools as well as the colleges were not in a position to accommodate all the students in higher secondary classes 11 and 12. Therefore, many high schools approached the government, the education department to upgrade their high schools to higher secondary schools. Assam Higher Secondary Education Council also made physical verification of the existing high schools as regards the need and feasibility of those high schools for upgradation as high secondary schools. The Secretary of Assam Higher Secondary Education by this letter issued under memo number so and so dated 3/7/1997 communicated the feasibility report of the high schools which could be upgraded to higher secondary schools to the Secretary to the Government of Assam in Education Department. Next paragraph, my lord. That the petitioner begs to state that Deputy Secretary to the Government of Assam had his letter under memo number so and so dated 2/3/1998 asked the Director of Secondary Education Assam to place the matter before the concurrence committee for their views. The proposal was placed by the Director of Secondary Director before the committee who advised the government to upgrade those schools. But unfortunately, the government was not considering the matter. On 5/2/2000, a meeting of the advisory committee was held whereby it was in its minutes, it was decided to consider the issue of upgradation during the year 2000-2001 due to the
How
financial,
does it matter, those issues? How does it have any relevance?
because my lord, due to the financial trans.
Where is that
schools
with the
could not be
question with
upgraded.
regard to promotion, your promotion to headmaster?
My
That's
lord,
all.
they
Don't go
were
into the
appointed-
other issue.
the petitioners were appointed in, as the government could not upgrade those schools.
So,
the
what is
government
the- what is
permitted
wrong?
the schools,
There's,
the government permitted the schools to appoint a
when
locally,
was the school, when was your school provincialized?
1/1/2013. 1/1/2013.
Then what is wrong? Have you challenged the provincialization of your school?
No, my lord,
Then-
I have not challenged that.
Yes, then, well, then if you have not challenged it, they've accepted it.
What I'm saying, my lord,
Ah.
what I'm submitting with your lordship, that from the date of our initial appointment, the authority permitted us, the government of Assam in education department permitted us to do our service. We were paid, we were paid,
Private school, private.
we were paid. It cannot be said to be purely private because the school managing committees were constituted by the government. The school managing committees appointed the petitioners and they were paid for their services in the name of financial assistance. As the government was not in a position to pay them on the regular salaries, they were paid the financial assistance. Later on, my lord, government took a decision to provincialize their services that amounts to regularization of their services, in fact, my lord. And the service they are rendering after provincialization and prior to the provincialization is the same service, my lord. It is not that there is difference in the service. Requirement for the promotion is the experience. Experience whether they have gathered prior to provincialization and after provincialization, there cannot be any difference because the same amount of work they are doing, my lord.
That's all.
And And as regards the appointment of the school inspectors, madam, they are the controlling authorities of the principals. In their case, my lord, appointment, their experience has been, my lord, it has not been said that their experience should be in a provincial school in respect of the inspector of schools and BEO.
Okay, that.
My lord, that apart, my lord, the rule was framed in the year 1982 initially, my lord. In the 1982 rules, it does not say that, my lord, they required the qualification experience in a provincial high school. Subsequently, it was amended in the year 2003, and in the 2003 rules also, my lord, there was no requirement for experience in a provincial high school. Later on, my lord, it was amended in the year 2012. In the 2012 amendment, my lord, the criteria of provincial high school was inserted, and that was adopted in 2018 also, my lord. The implement rules. So, my lord, even if, my lord, the OSIP doesn't hold the rule to be bad, my lord, by invoking Rule 33, the petitioners can be given the relief, my lord. The authority can invoke the provision of Rule 33, my lord. But may kindly peruse the Rule 33, Election Penal Code. Rule 33, my lord, it reads as follows, my lord. Where the government is satisfied that operation of any of the rules leads to undue hardship in any particular case, it may dispense with or relax the requirement of the rule.
Look, that is entirely the discretion of the government, depending upon whether they are not, if they are not enough candidates to be considered under Rule 12.
Well, considering the factual background of the case, the petitioner's
The
case,
background, basically what you want at the end of the day is that your service as a private teacher in a private school should be considered as part of your seniority. That's all. That's your basic case.
no, my lord, not seniority, my lord, for my lord, qualifying.
For qualifying years of service.
My lord.
That's all.
Otherwise, they are
Basically,
qualified, my lord.
You want your private years of teaching to be considered as in government service. That's all you want. Actually.
I'm not saying that it should be considered as government service.
Then what
I'm
should
saying
it be
that,
considered as?
I'm
Private
saying
service.
that by relaxing their, my lord, the requirement of the rule, their first services can be considered for, my lord, eligibility, my lord.
That is entirely up to the government. If you want that, we can tell them to let the government take a decision. If that is their case.
That can be done.
That, yes.
Relaxation is, if there is any ambiguity in the rule.
So no, what
that
he
can-
says, what he says now is that let the government consider if Rule 33 can be applied in it. And if it can be applied, I may be given the benefit of being considered for appointment to the post of headmaster or whatever.
Only for the purpose of eligibility, my lord. I'm not
Principal.
saying
It's a discretion of the government.
Yeah, right. So you take a decision. That is what he is saying. Otherwise, there is no case. Yes, that's all.
my lord.
You know. Heard Mr. Ayed Shakir, learned counsel for the petitioners. Also heard Mr. N.J. Khatane, learned counsel for the secondary education.
Secondary education
Secondary education department.
for all the respondents.
The petitioners are aggrieved by Rule 12 bracket 3 bracket Roman 2, comma Rule 12 bracket 3 bracket Roman 5, and the proviso to Rule 12 bracket 3 Roman 5 of the Assam Secondary Education Provincialized Schools Rules 2018, whereby their past services, comma prior to provincialization of their service, are not to be considered for the purpose of selection to the post of principal in higher secondary schools. Further, as the petitioners, as some of the petitioners have crossed the age of 57 years, they would be rendered ineligible for the purpose of selection to the post of principal. Full stop. Next para. During the submission, no, just right. Next para. During the submission, during the proceedings of this, during the submissions made by the counsel for the parties, the counsel for the petitioner has limited his stand to the extent that the state respondents may consider counting the past service of the petitioners prior to provincialization of their services, to allow them to participate in the selection process for the post of principal in higher secondary schools by exercising the relaxation clause provided in Rule 33 of the Assam Secondary Education Provincialized Schools Rules, 2018, hereinafter referred to as the 2018. Correct?
Fine.
Mr. N.J. Khataniar, the learned counsel for the Secondary Education Department, submits that he has got no objection if the prayer of the petitioner's counsel is allowed.
My submission, it is the discretion of the.
Which should be at the end, which should be left entirely to the discretion of the state government, state respondents, in terms of Rule 33 of the 2018. On considering, so we won't take a decision on merits. On considering the submissions made by the counsels for the parties and keeping in view Rule 33 of the 2018 rules, we direct the respondent number.
State respondent, my lord.
Huh?
Respondent number 1, my lord.
The respondent number 1 to take a decision as to whether the petitioners to take a decision whether Rule 33 of the 2018 rules can be made applicable to the case of the petitioners for the purpose of enabling them to participate in the selection process for selection to the post of principal in higher secondary. Now, the same should be done within a period of
4 weeks, 1
1 month from the date of receipt of a certified copy of the file. The writ petition.
Thank you.
Maybe the lordship. One of the state government has filed this appeal, my lord. The state government has filed this appeal. Now, needs an order for one single judge.
But they're not here.
Lordship may issue notice, my lord. On last occasion also.
This appeal has been filed by them.
By the state government, by us, my lord, by the government of Assam.
Appeal has been filed by you, by the,
Yes.
you whom?
We are the government of Assam, my lord.
Yes, for the staff. Yes. What is to be done?
Your lordship, Honorable single judge order Annexure 5, page number 123, lordship, order dated 5/6/2025. And prior passing this order, lordship, another order has been passed by this honorable single judge, lordship, by the order dated 31st of August 23, lordship, wherein directed the authority concerned to release the pensionary benefit by considering the such lordship. Being aggrieved, the respondent authority has filed an appeal before the division bench lordship, and accordingly appeal has been disposed of in a motion stage by the order dated 23/2/2025. Holding asks the authorities lordship to raise their grievances, if any, before the honorable single judge. And accordingly, they have filed another IA for modification and alteration of such order lordship, and thereafter honorable single judge has proper scrutiny and call for the entire record lordship. Wherein mention that your lordship.
So according to the learned single judge, you
Yes.
are entitled to family pension
Yes, your lord.
as per what rule?
As per the notification lordship, as per the notification, even not only the notification.
Where is the notification?
For notification lordship into their affidavit lordship, page number 79 and page number 79.
77, 77. But 77, madam.
Relevant portion, your lordship. 77 laws.
Yes.
Not only this notification, but notification is there, they have categorically mentioned,
Where,
your
where?
lordship. Yes, lordship, in column number 3, lordship, may I please to read it? Your
Yes.
A government servant who dies while in serving after having rendered not less than 7 years continuous service, the rate of family pension payable to the family shall be equal to 50% of the pay last drawn or the twice family pension admissible under the normal rules, whichever is less an amount so admissible shall be payable from the date following the date of death of the government servant for a period of 7 years or for a period up to date which the deceased government servant would have attained the age of 65 years, had survived, whichever is less, the family pension will be reduced 30% of the last pay basic pay drawn. In cases where the government servant had less than 7 years of continuous service, before that the family pension will be continued, the rate of 30% of the last basic pay drawn of the deceased employee. So, lordship, although my husband did not completed the 1 year's requirement service, is deemed to be complete, lordship, the 7 days.
Where does it
But
say?
lordship, 30% I am entitled to.
Listen,
Lordship.
where does it say 1 year? It says 7 years, not less than 7 years. Where does it say 1 year? Where does it say 1 year is required?
Madam, now nothing may come to the next page, madam. Page 78.
Yeah.
My last third para, madam, from below, madam, first.
Yes,
second,
yes,
third, madam.
yes.
And madam, as per the provision of the said scheme, where the employee dies before superannuation after completing minimum 1 year of continuous service. Now, this 1 year service is required. Now, this is a ON published by the government of Assam.
So what does the pension rule say?
My pension rule says madam, minimum 1 year.
The rule says minimum 1.
But your lordship, honorable single judge has categorically mentioned in the order lordship, kindly be pleased lordship, in column number 11 lordship. May I please to read, lord?
That's the page.
Page number 127.
127.
Column number 11.
Yes.
By communication dated 31st of 12/15 under number so and so, the Labor and Employment Department of the State informed the Director of Employment, Craftsman Training Assam about government approval with regard to the appointment of the husband of the petitioner, Popular Burman and other under grade 4, 5 grade 3 and 3 in grade 4 posts under the category reserved for differently able person, directing the state directorate to take necessary action as per Finance Department Office Memorandum number so and so dated so and so by following all norms and procedure indicating further that the same has approved of the Chief Minister of the state. So, lordship, prior filing the present lead petition, lordship, my husband earlier filed lordship lead petition in the year of 2011, lordship. But the recruitment process was challenged wherein carried out in the year of 2005, lordship. And being aggrieved such irregularity, lordship, in the year of 2005, lordship, wherein my husband, one of the petitioner in petitioner number 48, lordship, lead petition number 1424/11, lordship. Then lead petition was directed to the authority to regularize the pension service of the petitioner's husband, lordship. But lordship, that time, lordship, the authority has done the irregularity in the year of 2005, lordship, when the recruitment process was done.
Why you appointed?
Lordship, I was appointed in the year of 2018, lordship. 2018.
No, no,
But
no, no,
lordship,
no,
the
no.
court has directed, to,
19.
court has directed to
So basically,
appoint
what you are
within a
saying
period
is
of
that
4 months, lordship. But lordship, same was not carried out.
you are not hearing us, we are not hearing you.
I am bound.
It's not a one-way traffic that you keep on shooting off your mouth.
You know.
Don't do like that.
Rule 140 of the pension rule. Rule 140. Well, it says in case of death while in service, the government servant should have completed a minimum period of 1 year. Based on this rule, my lord, this OM was published in 2017. This was the OM published in lieu of the compassionate appointment. This is regarding compassionate family pension. But now he is claiming the compassionate family pension, which he is not entitled as per the OM, my lord.
Yes, Mr. Counsel. You see, basically, the single judge has held that though you were selected in 2015,
Yes.
due to the delay in your appointment order,
Yes.
the you could not be faulted for the delay, and as such, if you had been appointed earlier, you would have completed 1 year. That's what the single judge has
Yes,
basically said. Now, whether that finding can be correct. Is that a correct, can there be a correct basis for allowing you to take the benefit of the family pension, which is not in tune with Rule 140?
Lordship, earlier lordship irregularity has been admitted, which has been judicially been admitted by the respondent authority, that is here for lordship. Then lordship, honorable court has directed the authority to make an appointment, lordship. But at due course of time, lordship, they are failing to appoint the petitioner.
The court said that point.
Accordingly, lordship, all the department had take responsibility, and especially social welfare department, and the cabinet decision was taken in presence of the honorable chief justice. Then lordship, thereafter, being a nodal department of social welfare department, consultation with other department, yes, because the previous lordship single judge order 145 lead petition lordship, which was filed in the year of 11 lordship, disposed of in the year of 15, holding directed to take the responsibility. That is not the fault of my husband. My husband is special category lordship, PWD candidate lordship. The key number of irregularity was done by committed by the authority itself.
Where is this order where is this order passed?
No,
You were selected in on which date? You were selected on which date?
my lord, in that round of litigation, my lord, we are not the party, my lord. But this department was not the party.
Although no one made a party lordship at a relevant point of time, the court was directed to take responsibility to the cabinet decision. Government itself was the party at a relevant point of time. So lordship, the present department is under the guidance of the government lordship. So they must have to take responsibility. That is not fault of my husband lordship being a PWD candidate.
You were selected earlier.
Yes, Lord.
But you were not appointed.
Yes, Lord.
That's why you went to court.
Yes, Lord.
Well, and the writ petition was disposed of on when?
Lordship, in the year of 15.
The year 15.
15, Lord.
With the direction that you should be appointed.
Yes, Lord. Within a period of 4 months.
Then why was it? Why were you appointed in 2019?
Lordship, then in later stage, Lordship, contempt petition was filed, and thereafter, Lordship, recruitment process, I was called for the interview board, and thereafter, several round of.
You said you were selected already.
Although I was selected, Lordship.
Then why should there be interview? Why should there be interview after the single bench order?
Yes, Lordship, that is the certain requirement, Lordship, for verification of.
Where is all the orders and all passed? Let us see.
In those cases, we are not the party, my lord.
Whatever it is.
My lord. Not simply call the records, my lord. My lord.
You see, because there's something not adding up. Because you said that you were selected for some post, correct?
Yes.
You were selected.
Yes.
So interview done or not?
Interview was carried out. Yes, sir.
So you were selected.
Yes.
But you were not appointed.
Yes.
That's why you filed the case in 2011.
11, Lordship. And
that was decided in 2015.
15, Lordship.
With a direction that you should be appointed.
Appoint within a period of 4 months.
You should be appointed.
Yes.
Then they did not appoint.
Yes, Lord.
Then you filed contempt.
Yes, Lord.
And then after the contempt, you were selected.
Yes, I was appointed in the year of 2019.
Interview done after the contempt?
Yes.
Interview done?
No interview done, Lordship.
That's what.
Yes.
So 2015, so there was no writ appeal filed by them.
No
writ appeal.
writ appeal filed by the government, Lordship.
So 2015, you were supposed to be appointed, but you were appointed in 2019.
19, Lord.
But now the issue is that, madam, whether he is entitled for pensioner benefit or not, since he have not worked for a period of 1 year. Now, the rule is clear, and the OM, which Lordship has already seen at page 77, that has been prepared on the basis of this rule, madam. That madam, minimum 1 year is required.
There is another aspect.
Yes, madam.
In 2015, you were directed to appoint him within 4 months.
Yes, madam.
Why didn't you appoint?
But in that case, madam, our department was not a party, madam, in that case, madam. Please.
We have to see those orders. Why was he not a party in those orders?
Lordship, that time, Lordship.
Who selection was not done by his department?
No, Lordship. When the recruitment done was carried out in the year of 2005, Lordship, my husband rendered his services in master or worker, Lordship.
Bring those judgments. We'll have to see. You bring those judgments.
Lordship, call the records, madam. Records.
You bring them. We are not going to call the what? He is saving money. You call just print out the orders. Print out the judgments. That's all. On the prayer of the parties, this is the matter after 2 weeks.
No, Lord. It's my mechanism.
Huh? What?
Date may.
Give a date.
Lordship may take this case with this WBCs, madam, earlier WBCs. That will be it. Good for us, madam.
Those are disposed of matters.
But those cases are taken with the main case, madam.
You bring 2-3 orders, that's all. We don't have to have the entire record with us.
Madam, may I mention the WBC, madam?
Next. On 9, after that. Give it on 16. 16.
Thank you.
May I please, I'm on behalf of M. Ahmed.
Yes.
The appeal is filed the impugn judgment dated 17/6/2025 annexure 1, page number 1972.
What is your name?
S.U. Ahmed. I'm not in.
Mr. S.U. Ahmed appearing on behalf of Mr. A. Ahmed.
M. Ahmed.
M. Ahmed, learned counsel for the appellant, submits that the judgment dated 18/6/2025.
17/6.
17/6/2025. Passed by the special judge Udalguri in special bracket P, case number 27 of 2018, arising out of
Box case number.
Kalaigaon PS case number 114 of 2017. Under which, no, by which, by which the appellant has been convicted under section 6 of the POCSO Act should be set aside. Issue notice returnable in 5 weeks. Ms. B. Boya, additional PP, appears for the state. The appellant shall provide soft copy of the appeal to the PP, additional PP's office, who shall thereafter forward the same to the OC of the concerned police station for serving the same on the respondent number 2. Okay, before that, they admit the appeal, call for the TCR, huh? And issue notice. Okay. This is the matter after 5 weeks.
Obligement.
Right, Mr.
Yes, New.
Yes, New York learned counsel for the appellant who submits that the judgment dated 20/06/2025 passed by the special judge POCSO, Lakhimpur.
Provident Fund Authority to ask any person who owes money to the Provident Fund to direct them to make that payment. And that a power has been exercised. That your lordships will get at page number 59, Miller.
No, but you see, as per the order of this court,
Yes.
the single bench,
Yes.
you have not, there's nothing to show that you have given 1 crore 39. There is nothing to show.
No, those receipts are there, Miller.
But then this has.
Yes, receipts are from page 93 onwards, Miller. Page 93 to page number 107. These are all receipts of different amount.
After filing this.
After filing of the writ petition, Miller. 50 bahire, na? 50 bahire kiman? From Millard, page 93 to page 107.
Who is for the
Millard, notices will have to go. They do not have a standing counsel, Millard.
B. Sharma? Where is Mr. B. Sharma? Standing counsel for.
No, Millard, they are not standing counsel. They appear from case 2. Rakesh Sharma appears, Millard.
B. Sharma is there.
No. Rakesh Sharma. R. Sharma appears normally, Millard.
Single bench.
এখনো একজন আছে নাকি নাই
B. Sharma.
দিয়াচোন এইখন নহয় এইখন Milord, if your lordship would kindly come to page number 59, they have already invoked that power, Milord.
Unreadable. This also unreadable. This next also unreadable.
Milord, let the
This
man.
also unreadable. All the relevant pages are unreadable. 57 also.
Copy block beya. Well, what we'll do, Milord, we'll file a fresh one, Milord.
You file a fresh one.
Yes. We'll change the annexures, Milord. So type copy di diba.
Let's this matter again. Day after tomorrow. On Monday.
Monday.
This is a matter on Monday.
Monday, Milord. এগুলা কপি গুলা কিয় দিয়া হ্যাঁ
Item 23.
Paper book is ready.
Yes,
Nobody is there.
right. No one appears for the appearance. Paper book has been made and oh. Yes, so have you been given a copy of the paper?
No,
book?
no, Lordship. Paper book prepared, Lordship, but
Is there a extra copy there?
extra copy is there, Lordship.
I'll give it. Have you got, madam?
Yes.
Okay, give it to him. A copy of the paper book, which is in the record, has been furnished to Mr. I.U. Chowdhury,
Lordship.
learned counsel for the appellant in the court today. In view of the above, list this matter for hearing.
Lordship,
In
we fixed
usual-
the date. No, Lordship. He is in custody, Lordship.
When?
Since date of arrest, Lordship.
When?
After 2 weeks,
No,
Lordship.
no, when was it? When was he in custody? Since how long?
Lordship, from date of judgment, Lordship, date of judgment 24/10/2024, Lordship. Almost a day.
Ah, but he just got a copy. You want to do the IA?
No, Lordship, Lordship, we fixed any days, Lordship.
Yeah, list the matter for hearing. As said so, list the matter for hearing. I'll give a date.
15 September. Lordship, leave table, Lordship.
Yes.
Lordship, service completed, Lordship. Then supposed to appoint amicus curiae.
No need if they don't want to appear, why should we appear?
It's a matter of fixed hearing.
Only when they don't get notice. Has,
Last order, Lordship. Dated 23/7/25, last order. Lordship.
in case, there's a case, okay. No, that's a different thing. Whether notice has been serving on behalf of Mr. You just ask for the appellant, okay? In the court today.
26.
Huh?
Lordship, in this matter, the await service report. However, Lordship, the office note says that steps has not been taken.
That part.
But this is the steps we have taken.
Okay, right.
Here, Lordship, the steps has been shown to be taken on IA only. But we have taken together. We have taken together, but it is shown when order was not passed in the
No,
IA.
that is only to your knowledge. We don't know. We cannot go by.
Order was not in the IA. Order was in the main. So we have
You
taken
make a clarification. Okay, right. Heard, Mr.
A.R. Tohvinder, Lordship.
Tabitha learned counsel for the
Appellant.
appellant who submits that pursuant to the order dated 25/7/25, directing steps to be taken for service of notice upon the respondents number 1, 2, 3, and 5. The appellant had taken steps.
Yes, that's
on on 1/8/2024.
by registered force as well as usual course.
By registered post as well as usual post. However, the office note indicates that no steps has been taken by the appellant. In this regard, he has submitted a certificate issued by the registry showing that the appellant had taken steps for service of notice upon the respondent in respect of IA Civil 2304/2025. there is nothing to show that the appellant had taken step for service of notice on the writ appeal. Though Mr. A.R. Tabildar submits that steps had been taken on the writ appeal.
He did that. As well as I both together. we have-
The Mr. A.R. Tabildar shall approach the registry
Yes.
with regard to the above. And the registry shall make a note with regard to the issue of whether the appellant had taken steps for service of notice on the respondent on the appeal.
On the appeal. husband.
This is the matter when
After 2 weeks.
give it in.
After 2 weeks.
11th September.
11.
Lordship, may please, your Lordship, registry may kindly be directed to reflect the name of SC in the cause list.
May registry to reflect SC
APSC.
APSC in the public.
Much obliged.
If required, we may be allowed to take a very test steps also. That may be.
Full stop. Okay, in the event it is found that the appellant has not taken step
Yes.
for service of notice of the appeal on the respondent, they are allowed to take steps.
Test steps.
They are allowed to take such steps.
Obliged.
Until 27.
May I please, your lordship? Lordship, kindly.
This is complete.
Service complete.
Lordship, I have given the acknowledgement.
Okay, right. Ms. B. Boyan has submitted. Letter dated 24/8/25 issued from the Kanchudaram Police Station. That notice has been served upon the respondent. Accordingly, notice is set to be complete against respondent. As PCR has arrived, registry to prepare the people. List the matter after COVID.
Thank you, Lord.
Yeah, one thing you write, in the IA you write, the state has filed the written objection to the application under section 430 PNF.
May I please, your lordship? Lordship, in this matter, this IS has been filed under section 5 of the Limitation Act for condonation of delay of 701 days in filing date.
Mr. U. Chowdhury, ask for the
Madam,
applicant to submit that there is a delay of 701 days
1 days.
in filing the appeal against the conviction of the applicant under section 302 IPC. Ms. BB.
Legally.
Ms. B. Buyan, additional PP, submit that she has got no objection if the delay is condoned. Accordingly, the delay is condoned. Registry to register the appeal and list the same after 3. Is accordingly disposed. 29.
Right.
Notice was issued.
May I please, your lordship? As per office note 22/8/2025, no service report has been received till date.
So we have
lordship.
to wait. Right. In terms of the office note dated 22/8/25. No, in terms of the office note dated 7/8/25, notice had been issued to the respondent. Number 1 on 4/8/2025. However, there is no return of AD card or unserved notice as on date. This is the matter after a week.
Much obliged, Lordship.
Awaiting service report.
Item 30.
May please your lordship, with a delay of 91 days delay, my lord. As per office note dated 22/8/2028, notice service is not completed, and we have already taken step for dusty service, my lord, through the unit, my lord, officially. So, my
Okay, right. As per office note, notice was issued upon the respondents number 1 and 10/8/2025. Though dusty notice has been issued on 16/8/2025, there is no affidavit of dusty service till date.
affidavit, we have already
Well,
taken it, yes, ma'am. We
You have taken, but where is the affidavit?
affidavit is not there, ma'am.
That's what.
Yes, ma'am.
This is the matter. After 2 weeks to enable the respondents to file, to enable the applicants to file their affidavit of service.
Master.
31.
And there is a delay of 123 days. Last officer notice was issued.
Any objection? 123 days. No objection. What is that? Small fix.
In the petition, your lordship, there is no explanation.
What is the it's with regard to what?
Compassionate effort.
Compassion appointment. Right.
Hanson.
Absolutely no explanation.
Very bad explanation. Okay, anyway, right. Heard Mr. N. Sharma, learned counsel for the applicant who submits that there is a delay of 123 days in filing the appeal. Mr.
Get more.
Learned counsel for all the respondents.
Yes, your lordship.
Submit that he has got no objection to the delay being put. Accordingly, the delay is put. Registry to this is the appeal after a week. I is accordingly disposed.
Obliged.
32.
There is delay, my lord, delay is, my lord, 248 days delay.
Yes, any delay.
No, your
Okay,
lordship.
right.
And the only thing, your lordship, yesterday I filed a vakalnama, it is not there on record. And for respond numbers 14 and 15, they have expired. So the case
maybe
is
start
abated against it, the names is.
Start off.
Okay, right.
Respondent 14 and 15.
Heard Mr. S.K. Medi, learned counsel for the applicant appellant to submit that there is a delay of 256 days in filing the appeal.
56.
256 days in filing the appeal. Mr.
D. Bora.
D. Bora appears for
All the respondents except 14 and 15 who.
appears for all the respondents except for 14 and respondents number 14 and 15 who he submits have expired in the meantime. He submits that he has got no objection to the delay being proven. In view of the submission made by the counsel for the party and keeping in view the reasons for the delay, we find that sufficient cause for the delay has been made out. So the delay is accordingly confirmed. Registry to list the appeal after a week.
Connected matters.
Yes, well, I know the same judgment, well, another appeal is here. The delay is not condoned. The IA number 1753/2025, IML.
Huh?
The another matter, they must in same judgment, my lord, another we appeal file appeal, my lord. That is, my the delay is not condoned, my lord. So my lord, this matter may come along with that matter, my lord.
That's
IA, my lord. This
That different, that's separate, that's separate, that cannot come.
Yes.
This is the matter after a week, huh? I is accordingly disposed of. Then, with regard to striking them off, it will be only after the appeal is registered and listed.
Yes.
Right now, it has not been registered.
Yes.
And this respondent 38 and 37, 9 months, this is pro forma respondent, Union of India.
How does it matter?
No, my friend cannot just it.
No,
He says only for the respondents. He does not talk about performer respondent.
Yes, sir.
May it please your lordship. Lordship, this IA is for condoning the delay of 106 days.
We issue notice. Heard, Mr.
Yes, Bull.
S. Barwa,
Yes.
learned counsel for the applicant who submits there's a delay of 106 days in filing an appeal against the judgment and order dated 27/3/25 passed by the learned principal judge, family court -1, Kamruk M at Guwahati in Miss bracket J, case number 167 of 2019. Whereby the monthly maintenance amount of rupees 6,000 per month has been enhanced to rupees 9,000 per month. Correct? Issue notice returnable in 4 weeks. Applicant to take steps for service of notice within 2 days. List the matter after 4 weeks.
Deeply obliged.
34 and 35.
These matters were admitted for hearing, my lord, on 23/5. They date be fixed, these matters.
When do you want?
IA is for early hearing.
When do you want? Give a date. Give me that, give me that, give me that.
Well, in the affidavit in opposition, we have said that already the state cabinet has approved the amendment. And we have sent it to the for presidential assent. That assent has been given and the amendment has come in the month of May 2025. So the particular Act of 64, which is under challenge, it is now available in the 5th schedule to the 2013 Act. Earlier it was not there. So in that view of the matter, Lordship, they have to take a call whether they will continue with the challenge or not.
Let them place that on record, my lord, then.
It is a gazette notification. We have given the copy. We have given the copy.
Reply, lord,
No.
You see this?
I have. I'll.
Let him see it now.
Yes.
Look, let these matters be taken up for hearing and then.
You see this figure?
Because, the acquisition relates to the year 2018, even if the amendment comes now. It's a different aspect of the matter whether it will validate, because there has to be a validating clause also. So all these matters, these aspects of the matter can be taken up at the hearing of the petition, perhaps. Any date can be fixed.
When do you want?
Any date will be convenient.
After the vacation.
On a hearing date.
Give a date, both of you.
Not
you look at your busy schedule and decide on.
14 October.
Decide on a date.
14 October. 14.
23rd month. On 23rd.
23rd October.
Mr. A. Ganguly, Learned Counsel for the applicant, and Mr. E. Nath, Learned Senior Government Advocate, pending for the state. Submit that, appraise that, and Miss and Border for Revenue Department. Pray that submit that the matter can be fixed for admission hearing on 23/10/2025. On considering the prayer of the petitioner and keeping in view the order dated 23/5/2025 passed in WPC 5626 of 2024 and 5624/2024, wherein it had been observed that the matter required consideration. No, go further. No, forget that, don't say. What have I said? Keeping in view the submission made by the counsel for the party, the prayer of the party, release the matter for admission hearing on 23/10/2025. The IA is accordingly disposed of. This IA of 2722 of 2025 and 2771 of 2025. Both disposed of. That's all.